Item number 35. It is become. Yes. State Sharma, the learned counsel appearing on behalf of the subject, that the instant repetition has become infructuous, for which he has instructions to withdraw the instruction. Taking into account above, the instant repetition has closed on withdrawal. In time order, if any.
Wait, please, in item number 42, my lord, we have filed affidavit in opposition. That may be called. In item number 42, my lord, we have filed affidavit in opposition yesterday, my lord. That may be called.
44.
42, my lord.
Okay.
It is your lordship. With regard to my lord, item number 21, my lord, your lordship may not like to take up this matter, my lord. As my lord, has already in consideration, lordship. Lordship, the petitioner might have consulted with your lordship, my lord, so your lordship might not like to take up.
21 listed before any other page.
Wait, your lordship, with the consent of the other side, I beg to make item number 39.
39.
Your lordship,
Yes. Why?
your lordship, can it be taken after vacation?
Why? Then I for what?
IA for direction for joint verification of the land required for Lower Kopili hydroelectric project.
Then there was a direction earlier passed by this court in this matter, where they have a thought for time because of the weather being not good,
Lordship,
isn't it? Then we'll take it up. Don't worry.
lordship.
I will do. I beg to mention item number 2. Better maybe adjourn for the day. Adjourn for the day.
Item number 2 for what?
My senior is absent. My senior is absent. Mr. B. Sinha is absent.
Your senior?
Senior. My senior Mr. B. Sinha is absent today.
Absent. Okay. At the request of the learned counsel for the petitioner, matter stands adjourned to be listed after the winter vacation. Madam, in those bail matters yesterday, except one matter, earlier other matters I have not insisted on sending it to the because of the fact that on checking the records, I could find out there was no date fixed in those matters. And when the date is not fixed, then obviously the PP cannot be asked to have the case record at all points of time. Those matters, they were fixed it as listed after the Puja vacation. Although I don't endorse the view that in a bail matter, you have to fix a date. Without fixing a date, it becomes a problem. Anyway, can't help it when a coordinate bench does this. Only one matter, I think I have.
Lordship.
At number 1, promotion.
Mr. Lordship.
But
at matter part of the demarcation of land matter. There, my lord, petitioner in fact had earlier approached my lord the honorable court matter, and the honorable court has directed the circle officer my lord to supply the names of the co-partners my lord who had been encroaching the land of the petitioner matter. Those persons were not the part of the earlier proceeding my lord. Now they have been implemented my lord.
what is there to declare as illegal?
My lord?
What is there to declare as illegal?
My lord, they are encroaching the land, my lord.
So, go before the civil court.
My lord, the circle officer as well as DC, they has been intimated already, my lord. They have not taken steps
For
demarcating the land.
So that is only the thing. The other aspect cannot be looked into in a writ.
My lord, at least, my lord, yes, my lord. The circle officer as well as my lord, DC, directed, my lord.
Show me your application for demarcation.
My lord, says, says 28, my lord. Honorable is 29.
Huh?
28, my lord.
28. Then you filed it on 14/12/2022. Thereafter, what happened?
Thereafter, my lord, no action was taken.
Then?
Thereafter, my lord, what happened, my lord, since no action has been initiated by the circle officer, my lord, the petitioner had earlier approached.
Obviously, if you don't give good reasons for that,
No, my lord,
urgent needs, I want a
No, my lord.
demarcation.
kindly see
What is this type of application?
my lord, kindly see, my lord, the part of the order, my lord, what they are reflected, my lord. Page 35, kindly do that.
Yes.
Yeah, my lord.
Then
Now, my lord, this,
now you have got the names.
yes, my
So,
lord. Now, my lord, they are being implemented.
so
Now, my lord,
why would this court take into account all these things?
my lord, and my lord, they are ancestral and my lord, they are consistent.
Understood. Isn't it, Mr. Hawk, the right thing to do? File a suit.
Yes,
Then why are you not filing a suit? Get the decree out there that this is your land and ask the revenue authorities out there for issuance of a commission that this is my plot of land. You can ask.
yes, sir.
Why are you not asking? How can this court give it all there?
My lord,
Why should this court on the application filed in the year 2022 should after 1 year pass an order?
my lord, they kindly see the, my lord, one office memorandum, my lord, case 40, my lord. There is specifically provided, my lord, if an application for demarcation is filed, my lord, that should be disposed of. But that has not yet been done.
Then file a contempt if that is given out there.
40, my lord, kindly see. Case 40. Procedural steps for instance of demarcation certificate. Then, my lord, kindly.
Because what is going to happen is you are not going to get a relief for another 2-3 years in this matter. Appear. But this court is not going to pass an order in absence of the other persons. Service is to be completed, which means then, and by the time nothing is going to happen. At best, this court can pass an order that why you are not doing it, that's all. Nothing more than that. But your effective thing is there, your case is these people are encroaching upon your land. Shouldn't it be proper? Anyway, I am not to advise you. Hello? Issue notice
1, 2, 3, madam.
making it returnable on 14th of February 2024. 14th is closed. Oh. On 12th of February 2024. Ms. Udas, the learned additional senior government advocate, appears on behalf of the respondent numbers 1, 2, and 3. Extra copies of the writ petition be served upon her during the course of the day. As regards the respondent numbers 4 to 30, the petitioner is directed to take steps by way of registered as well as usual by tomorrow. On the returnable date, the official respondents shall apprise this court as to why the application filed by the petitioner seeking demarcation had not yet been, as to why the application filed by the petitioner seeking demarcation have not yet been considered.
And number 3,
Your Lordship.
Yes.
Hello, the petitioner here was a landless person. He prayed for settlement of land to the government, and government was pleased to settle land with him in the year 1992. But he got settlement to possession and paid the premium also. The same go, some 7 more persons were allotted land, and in their case, Lordship, the measurement of the land was larger, where the price was low. In the case of the Lordship will kindly come to page 74, 13. The Lordship will find some 7 other persons were also allotted land.
You were allotted land. You have been allotted the land. Settled. And have you been,
Premium I have paid.
then why are you asking for premium?
Lordship, my case is, this, apart from this discrimination, Lordship, I prayed for another 9 lesser of land, because in their case it was 1 katha 10 lesser. In my case it was 1 katha 1 lesser, and I paid larger amount, 31,500. In their case it was 22,680 each. So and that was never granted.
So 1 katha 1 lesser has been already settled. You are only in respect to the 9 lessers of land. Have they granted the allotment to you?
No, for the 9 lessers I have not.
And the instant writ petition is on the 9 lessers of land.
9 lessers.
And in Guwahati, what is the land which is being allotted? How much? 1 katha 10 lesser. As per the land policy. Huh? Where is the land policy? Yes, revenue. How much? Guwahati? How much land do you allot? As per your land policy. Hey, igon kunu naya ta nahi. Land policy kon ta. I think it's 1 katha.
one katha 10 lesser, madam.
Guwahati, na?
Yes, madam.
So here, 1 katha 1 lesser has been allotted. Another 9 lessers is left.
As per their statement, representation is lying before the revenue department, so I have to take instruction.
In fact, my lord, I have to submit Lordship. They allowed this, asking me to deposit a premium, which was quite large. I could not pay Lordship. And thereafter, they
Now for 9 lessers of land, what is it? 9 lessers of land, I think let us issue notice to them.
My lord.
Let us get to know what they have to say on this 9 lessers.
My lord.
Yeah, 9 policy on 9. Issue notice making it returnable on 7th of February 2024. Ms. P.R. Mohanto appears on behalf of the respondent number 1 and 2. 1, 2, and 3. 1, 2, and 3.
1, 2,
1, 2, and 3.
3,
1, 2, 3, 4.
4.
Full stop. Mrs. Yudas appears on behalf of the respondent number 5 and 6. Full stop. As the respondents are duly represented, extra copies of the writ petition be served upon them during by tomorrow. Full stop. The case of the petitioner herein is that the petitioner was allotted a plot of land. A petitioner had applied for allotment of a plot of land measuring 1 katha 10 lechas. However, only 1 katha 1 lecha of land was allotted to the petitioner. However, similarly situated persons were allotted 1 katha 10 lecha of land. Mr. C. Chaudhary, the learned senior counsel, submits that it is the mandate of even the land policy of 2019 that in Guwahati, in the city of Guwahati, the land which is to be allotted is, that can be allotted is 1 kata 10 lechas. Under such circumstances, the petitioner had filed applications time and again before the respondent authorities for the purpose of allotment of the remaining 9 lechas of land which is in possession of the petitioner. You are in possession?
I'm in possession.
However, the said application had not been considered, and for which the petitioner has approached this court. The responding authorities shall, on the returnable date, apprise this court as to why the application seeking 9 lechas of additional 9 lechas of land have not yet been considered. And if so considered, what is the present status? First,
As per their statement, my lord, 9 letters already settled. They are agree for one premium, my lord. They said that premium is higher than earlier.
you are only agree with the premium.
No, not only that, my lord.
Has the 9 lechas been
At-
settled?
At one point of time, they settled, but I approached them that I cannot pay so much of premium, so it may be considered. That they didn't consider, and if lordship comes to page 93 and it's 21.
You have been settled.
Yes, it is
No.
settled, my lord. They
No.
agree only
Here,
for
lordship is fine.
premium part. They said that it is higher. They cannot afford.
Where is the settlement order?
Page 71. Lord.
So you agree with the
Premium.
premium.
But if your lordship comes to page 76,
Then what is your right? No need notice for issuance of notice. You don't pay, it is good.
Yes,
lordship, it is still under consideration.
So what?
It is still under consideration.
Very well, let it be considered by them.
No,
But where is the question of this? Yes, you are getting 9 lessons at 7.50 in Ulubari. Where will you get it? Kolkata.
My lord, it is,
You don't want it. Anybody else will take it. You want to take it, I suppose. Everybody wants.
my lord, at least notice.
No notice. This is not a case for notice.
Premium they have
It
to
should
pay,
be
my
case. It's a case for dismissal right away.
No, lordship, what is going on between them? It is at page 93, lordship will find. Therefore, you are requested to assess the settlement premium of the land as mentioned in the said letter as per zonal value for the year 2007 and 2022 now. They are dragging it like that, Lord, separately,
No,
and
my lord.
submit the same to the department.
Are you willing to pay as per page 71 or not?
Once I paid also, but they didn't issue the salan, accept the salan.
No, Mr. Chaudhary, are you ready to pay as per the 71 or not? Page 71.
That we offered. Lordship.
No, then why are you aggrieved? Show me that.
Then they didn't accept it. Lordship.
Huh?
They didn't accept it.
Which one?
In the year 2012, I offered.
Where is it? Well, let us see your representation.
77, Lordship, page 77.
Yes. Page 77 is 1,35,000.
Yes, Lord. That is 40% of the value of one katha. Sorry,
No, how much it is?
9 letters.
So they have put it at what?
If they accept this amount today, Lord, I am ready to pay.
You are to pay 3,37,500. for 9 letters.
Yes, my
No, it is 40% of the land. That's what. The premium should be 40% of the land.
Resident is subject to payment of 40% of the land value at premium.
Lot.
Land value is 40%. Then you paid that. Then what happened?
They didn't accept that payment and they didn't allow me because the process demands that it has to be approved by the deputy commissioner. That plan has to be approved by the deputy commissioner, then only I can deposit. If that opportunity is given by our lordship, we are ready to pay now.
My lord, page number 79, my lord. Page number 79.
When did you pay this amount?
2012 lordship.
Why? After 5 years?
There was delay. I paid for condonation of the delay.
Then? Why after 5 years?
Under constraint lordship. Not pay. That was my prayer. I was not capable of paying that amount at that time. So when I gathered the money,
So now what is their stand?
the stand is page 92. lordship. 90, 96. This 90.
96.
Joint Secretary writes to the Deputy Commissioner to make an assessment. As per journal value for the year 2007 and 2022 separately, and submit the same to the department for further necessary process. From their end, the process is still on. Problem of the petitioner is the value of the amount of the.
Yes, madam. Understood. After 5 years, they paid.
Well.
But did you mention within what time you are to pay the amount? Or did you mention in your allotment order that if you don't pay within this, the allotment would be cancelled? Because normally it is done. We have seen all these allotment orders and all.
Yes, my
Yeah. That you have to pay this amount within such and such date. If you don't do it, it will be cancelled. But you have not cancelled the settlement order.
As per page 93, my lord.
Page 93 is what? Inviting reference is a subject. I am directed to forward a copy of the letter dated for settlement payment of the settlement premium of 20. Requested to
Not
access
cancelled,
the
but
settlement premium of the land as mentioned in the remand as per the zonal value of 2000 separately and submit the same. No, this is nothing. This is a correspondence only.
it's not cancelled, my lord. The department request
Now,
the
if you have
deputy
not
commissioner.
cancelled, you have not put the period. Now, can you increase it?
Take
The issue notice kini thako. The instant writ petition has been filed by the petitioner. Being aggrieved by the actions of the respondent authorities in not accepting the premium so paid by the petitioner in terms with the order of settlement dated 27/11/2007. First, a perusal of the writ petition reveals that though the petitioner had applied for a plot of land measuring 1 kata 10 lechas, but a plot of land measuring 1 kata 1 lecha was initially allotted to the petitioner, for which the petitioner had duly paid the premium. The said land has accordingly, therefore, have been settled. However, as additional 9 lecha of land which was not settled, the petitioner filed various representations, and thereupon, on 27/11/2007, the Undersecretary to the Government of Assam Revenue and Disaster Management Department informed the Deputy Commissioner Kamrup Metro that the Governor of Assam had recommended for settlement of government land measuring 9 lechas covered by DAG number 1601 (PT) of village Sohor Ulubari Part 2 under Ulubari Moja with the petitioner for residential purpose, subject to payment of 40% of the land value as premium. The land value was fixed at rupees 7,50,000 per kata. On account of financial difficulties, the petitioner could not pay the said amount, and in fact submitted a representation to the effect that the petitioner should be permitted to pay at the same rate at which the petitioner had earlier paid for 1 kata 10 lechas of land. However, the records does not show as to what further actions were taken by the respondent authorities thereafter. Be it as it may, the petitioner, on advice, deposited the land premium in terms with the communication dated 27/11/2007 in and around October 2012, and duly intimated the Deputy Commissioner Kamrup Metro by the communication dated 30/10/2012. However, the responding authorities have not accepted the said premium, and the petitioner thereupon had submitted various representations to that regard. It is also seen that There's a communication dated 15/11/2022 by the Joint Secretary to the Government of Assam Revenue and Disaster Management Department to the Deputy Commissioner Kamrup relating to the instant land. And there is also a direction to assess the settlement premium of the land as mentioned in the letter received from one Dr. Arun Kumar Sharma, ex-MP. As per the zonal value for the year 2007 and 2022, and submit the same to the department. The petitioner therefore apprehending that the value of the land, that the premium to be paid to the land would further increase, taking into account the value if taken for the year 2022, has therefore approached this court by filing the instant writ petition. The respondent shall apprise this court on the returnable date as to why the petitioner's premium had not been accepted, even though the communication dated 27/11/2007 does not specify within what time the premium had to be paid. Further to that, the respondent shall also intimate this, apprise this court as to whether the settlement which have been recommended by the communication dated 27/11/2007 had become redundant. The proposal as to whether the recommendation so made for settlement of 9 letters to the petitioner, as communicated by the communication dated 27/11/2007, had become redundant for non-payment of the rent premium.
Policy, my lord, premium for settlement shall have to be deposited within revenue year, my lord, in which the order of settlement is issued, or within a period as may be notified by the government, failing which the order for such settlement shall
Get your instructions. This court, one thing, Mr. Chaudhary, I'm just keeping it. The question of delay, I'm keeping it open. There has been a considerable delay for you to approach this court. This happened in the year 2012. We are in 2023. The question of delay in latches in moving the instant in approaching this court shall also be considered on the next returnable date.
If I had been making correspondence with the authority,
Correspondence, but that is why it has now become 2022. If you have approached in 2014 also, then they would have never gone for the 2022. Yes.
So this is a GST matter. I have come against an appeal order after the first appellate authority, but because the tribunal is not there, I am not able to file a statutory appeal under the Act. And in the meantime, after the lapse of around 1.5 years of the order, Now department has issued me a letter for initiation of garnishing proceedings. Lordship, that letter is at page number 126. My Lordship, sir, may I take you, Lordship, to this letter? Page 126, Lordship. Lordship, this letter is dated 6/9/23 and it refers to the subject non-payment of government dues. Lordship, in this regard, I just read from the starting. Dear taxpayer, kindly refer to OIO number dated this, passed by the Assistant Commissioner CGST Dibrugarh. Also refer to the OIA dated 31/3/22, passed by the Joint Commissioner Appeals, Guwahati. In this regard, you are requested to pay the demanded amount as mentioned below, central tax, interest and penalty. The aforementioned mentioned liability is arising out of OIA dated 31/3/22, passed by the Commissioner Appeals, Guwahati, arising of the appeal filed by you against the OIO dated this, passed this office. Failure to comply will lead to recovery proceedings initiated under section 79 of the Act, which is the garnishing procedure. Now, Lordship, section 112 of the CGST Act as well as the Assam GST Act provides that an appeal, statutory appeal after the first appellate order can be filed before the GST appellate tribunal. In 2019 December, the CBIC came up with a circular extending this time because of non-constitution of the tribunal, 3 months to be reckoned from the date of constitution of the tribunal. So, Lordship, 112, then in March 21, the board came up with a circular again to clarify this order that this 3 months is to be calculated from the date the president or the state president takes charge and when the tribunal is formed. So, Lordship, in the meantime, because the appeal order has been passed, I don't have a statutory remedy. I was keeping quiet.
Are you hinging only on the question of alternative remedy?
Lordship,
Or what else?
Lordship, I am on merits also.
Come to the merits.
Oh, I am on the merits, Lordship.
Yeah.
Lordship, as regards the merits, the matter relates to Tran 1 credit, Lordship. Lordship, I was under the excise regime of unit registered SSC under the Excise Act and my unit was at Assam. Tran 1, Lordship, had to be filed by 31st of October 2017. Tran 1, I could have taken the credits of my closing balance of Senvet credit in the excise regime. So 30th June 2017 was the last return, was the last date, cutoff date for the old regime, and 1st July 17, the GST regime came, Lordships. Now, Lordship, 30th June 2017, I had to file my June return in the week within 10th of July, ER1 return. I filed that ER1 return, Lordship. In that ER1 return, Lordship, because I was under the Northeast exemption, so there was a system of self-refund, self-credit. Whatever amount of duty I pay through cash ledger, that would have been refunded to me suo motu myself. I filed that application for the month of June also, in the month of July, on 7th of July, and I was waiting for the department to give me an instruction to recredit. But that instruction never came. So as a bona fide SSC, because I had to file Tran 1 before 31st October, I took that credit in my Tran 1. So there are two portions, Lordship. One is this self-credit under the Northeast Exemption 50/2007. And second is, Lordship, in excise regime, there was a account current. Account current means, Lordship, there was a PLA balance. I could have deposited X amount in my account current, which was used to set off my excise duty liability. Now, as on 30th June 17, I had a balance of around 19 lakhs in my account current. I had a balance of 19 lakhs in my account current. So, Lordship, because the statute didn't provide any clear guidelines as to what will happen to this account current balance, because it is already deposited with the government's exchequer. It is not lying with me. It is with the government's exchequer. So, to that extent also, I took this amount of closing balance of PLA and my self-credit in my Tran 1. I wrote to them also. They informed me in January 2018, stating this credit that you have taken, you should have filed a refund claim in the erstwhile regime. And then the proceedings of show cause notice, the adjudication order, and the first appeal happened. So on merits, Lordship, it's a clear case. They are not disputing. It is not a case where they are disputing that this amount is not eligible. They say you have filed a Tran 1 under section 140, but what you could have taken is a closing credit balance, not your PLA balance and not your self-credit balance. This is the only issue, and they admit that it was refundable to you under section 11B of the erstwhile regime. But Lordship, that communication came to me only in January 18. By that time, my Tran 1 date had already...
Mr. Counsel, how do you make the payment of the GST?
I make the payment of GST.
There are two methods,
Okay.
either by cash ledger
Lordships.
or by
Credit ledger.
credit ledger. Now, credit ledger will How is the credit ledger to be formed?
Lordship, credit ledger is being formed on the basis of what my suppliers are filing their outward supplies GSTR 1. It is auto-populated in my GSTR 2A. That auto-population based on dot auto-population matching with my books of account, I take that credit in my GSTR 3B. So there's a return 3B.
Mr. Counsel, don't make that thing so technical as to which form I am concerned.
Lordship,
Let us make it very simple.
Lordship.
The question is out here, you can pay the GST by two modes, either by cash ledger or by electronic ledger, which is already there on the basis of the input tax credit. That's it. We are not concerned with all these forms and all. Now, can you bring the refund which was to be, you would have got on the basis of that particular document or any refund as per that notification, the industrial policy notification, within the ambit of the GST for claiming that benefit?
It is not that benefit I am claiming. I wrote to the department stating last month, 30th June 2017, I was entitled to this self-credit because had GST not set in, I would have taken that amount in my self-credit ledger in the excise regime. I wrote to them.
But when the Act does not permit, does the Act permit for taking that aspect of the matter in the GST payment?
That is the dispute.
That is the only dispute, that is the only clarity. The Act does not permit that.
I'll place, I vote on your Lordship's query. Lordship, section 140, subsection 1 provides for transitional credit. There is no disputes with that. They say whatever is your closing credit balance, that is entitled to be carried forward to the GST regime. Excise
credit balance, how?
There was a form, TAN 1 form which
the credit balance where? On the basis of the input tax credit?
No, Lordship, no. TAN 1 is not the input tax credit. TAN 1 was the closing credit of the excise regime.
Show me that.
Lordship, section 140 subsection. May I please?
Take it.
I am carrying 2 copies there, please.
Then
Lordship, section 140.
Yes.
Transitional arrangements for input tax credit. A registered person other than a person opting to pay tax under the section 10 shall be entitled to take in his electronic credit ledger the amount of Senvet credit of eligible duties carried forward in the return relating to the period ending with the day immediately preceding the appointed day furnished by him under the existing law within such time and in such manner as may be prescribed. So, Lordship, it says Senvet credit of eligible duties in the return relating to the period ending the day immediately preceding the appointed day. Appointed day is, Lordship, 1st July 2017. Senvet credit of eligible duties is explained under explanation to section 140 to include service tax, excise, additional duty of excise, all these things.
Yeah.
So this was the form which had to be filed, Lordship, by 31st of October 2017.
So whatever Senvet credit you had,
Lordship,
that you can use it.
Lordship,
That you can use. Okay.
and that
Now,
was,
are you saying that the refund which you were supposed to get in view of the industrial policy benefit,
Lordship,
that you were trying to use it for the purpose of in terms with section 140?
Lordship, exactly, I go down to your Lordship.
Yes.
So, Lordship, there are 2 components of this. One was the refund, self-refund for the month of June only, which I had to recredit. And the second component was my closing credit, my closing PLA balance. So they have issued me notice for both the balances. For the month of June, Lordship, I was entitled to a sum of 15 lakh rupees as self-credit on the basis of whatever I declared as my output tax liability in excise and paid it through cash. So that I was entitled to credit. And second one was my running balance of my cash ledger in the excise ledger. So both of these where I was entitled to, because these were already audited balances. There was no dispute as to I was not eligible for this claim. So the department is not on that also, Lordship. Department says when 140 subsection 1 is read, it says eligible duties. So department says this eligible duties will not include your self credit and your PLFL. Lordships, that is the point. And 9th January 2018, my problem was, Lordship, the cutoff date to file TAN 1 was 31st October 17. Communication was made to them. They replied on 9th January 18. Lordship, how can an SSE who is already a bona fide SSE who has written to the department by a communication, post-dated communication, be denied this credit?
Now, what do you say about the proviso? Proviso Roman.
Provided that the registered person shall not be allowed to take the credit in the following circumstances, namely,
1 and 2.
Where the said amount is not admissible as input tax paid under this act.
No, we are not concerned.
We are not concerned.
Number 3.
Where number 3, I will directly read number 3, Lordship. Where the said amount of credits relates to goods manufactured and cleared under such exemptions as are notified by the government. There is no notification by the government. For the disallowance of this credit, in TAN 1, there is no such notification issued by the CBIC that you cannot take this credit. Lordship, there was a notification.
Where is the mention that you cannot, there is required to be a notification that you can't take the rate? Here it says where the said amount of credit relates to goods manufactured and cleared under such exemption notification as are notified by the government.
So, if they want to deny me this credit, they have to notify for the purposes of 140 subsection 1. These are the notifications which will not be entitled to any credit under the GST regime.
Why?
Because they say where the said amount of credit relates to goods manufactured and cleared under such exemption as are notified. So such means they will notify, they will give us the list, Lordships. They have given one list, Lordships. Kindly, I'll take you to that notification, Lordship. There is a notification at page 145 of the petition, Lordship. Notification 21/2007. No, Lordship. I apologize, Lordship. It is. Lordship, I apologize. Lordship, just gives me a second. Lordship, that notification is the extension notification for 3 weeks. That is not relevant, page 155. Lordship, the CBIC has not notified any such notification which would be not entitled for the purpose of carry forward of such credits.
Now you are only against this order. This order comes from which one? Demand comes so called.
page one, Lordship is referring to page 110, appeal order.
No, the order which you have challenged.
Lordship, there's a recovery notice and the order appeal order.
You are bringing to the notice of this court 126.
Lordship, 126.
126 arises out of which order?
It arises of the order in appeal dated 31st March 2022, which is at page number 110, Lordship. Page 110, Lordships. And kindly takes the preamble of this, Lordship. That is also very important, Lordship. The page 1111, first paragraph, Lordship. The preamble. It says, any person aggrieved by this order may under 1112, subsection 1 of the Central Goods, read with Rule 110, file an appeal electronically or otherwise in the appropriate state area bench of the appellate tribunal constituted under 109, which is not yet constituted.
No, we are not on that.
Lordship.
Let us come to that.
Lordship. On the merits, Lordship.
Which order we are concerned?
Lordship. The discussion and finding starts at Lordships, page number 117, last paragraph, para 7.
And how does this appellate authority take note of the 140 page?
Lordship, that is at page 119, para number 11, Lordship. May I place before your Lordship?
Let's see 142.
Lordship, I am on board. Lordship, 142, there are various subsections. The relevant subsection for why the appellate authority has referred it, Lordships, may kindly takes the 142 subsection 8 subsection clause A.
8.
8, Lordship. May I please be Lordship?
Yes.
Where in pursuance of an assessment or adjudication proceedings instituted, whether before or after the appointed day, under the existing law, any amount of tax, interest, fine, or penalty becomes recoverable from the person, the same shall recover, unless recovered under the existing law, be recovered as an area of tax under this act, and the amount so recovered shall not be admissible as ITC. B. Where in pursuance of an assessment or adjudication proceedings instituted, whether before, on or after the appointed day, under the existing law, any amount of tax, interest, fine, or penalty becomes refundable to the taxable person, the same shall be refunded to him in cash under the said law, notwithstanding anything to contrary contained in the said law, other than the provisions of 11B2 of the Central Excise Act, and the amount rejected shall not be admissible as ITC. So, Lordship, kindly takes page 43, Lordship. The first letter where they refer to this initiation of the proceedings. Page 43, Lordships, dated 9/1/2018.
Yes.
Lordship, page 43, Lordship.
Yes.
Letter dated 9/1/2018, Lordship. It says, subject wrong availment of transitional credit of this. It is to inform that you have availed rupees this under transitional provisions of section 140. It has been informed that you have taken PLA closing balance and self-credit balance amounting to this as transitional credit, but CGST Act does not have any provision regarding the carry forward of PLA balance into transitional credit. However, the same may be claimed as refund as per section 11B of the Excise Act. You are requested to reverse the amount as again. This was the communication, Lordship, 9/1/18. My last date to file Tran 1 was 31/10/17. We had applied for the refund for the self-credit. All the letters were exchanged with the department. They on 9/1/18 by this letter state you should have claimed refund. By that time, I've already taken the credit, and this credit, once it flows in my credit ledger, Lordship.
Now, have you got the money or not? The PLA.
PLA money was carried forward in Tran 1, which was used in GST regime to set up the GST liability.
You used it, but otherwise it is not permissible under 142(8)(b).
142 will not be applicable in this case. 142(8), why they refer to 142, they say, suppose, Lordship, just for an example, if there is a service tax matter going on, because legacy matters are still going on, Commissioner Appeals gives me an order in favor. Now, I had deposited 7.5% of the tax while filing the appeal before the Commissioner Appeals. So I had to take the refund of that. Because of section 174 of the CGST Act, which is the repeal and saving provision, the provisions of the Finance Act and the excise regime has been repealed from 1st July 2017, except to the things to be done for the matters which are pending. So 142(8)(b) is for those cases wherein in any appeal proceedings or adjudication proceedings, either any demand is there or any refund is there. It has to be done in cash under the existing law. That is what the essence of the transitional provision is.
Now, here is a whether before, on, or after.
Lordships. After, because they can institute today, service tax has become time barred on 31st December 20, Lordship. So post GST regime also, department has conducted service tax audit, excise audit. So after GST regime.
But in respect to the PLA account, isn't there adjudication done every month?
No, Lordship, because it is self-assessment. Under excise was a self-assessment, Lordship. Whatever we file under excise return, ER1, was self-assessed. Similarly, GST regime section 59, it is self-assessment. Whatever you file, it is a self-assessment.
No. For the purpose of claiming the refund,
Lordship,
you have to file it.
I had to file a refund application.
And there is an adjudication order done every month.
Lordship, no, Lordship. In this 20/2007, there is no adjudication order. Because the refund is basis whatever you pay through PLA. You file an application and they issue a letter, okay, this much amount as per ER1 is admissible as paid. Because
But wouldn't that come within the ambit of an adjudication? Accepting your return?
Lordship, that is what, Lordship. So That process was carried forward. They never replied to it because this notification under which I was taking the self-credit had become redundant from July 2017. But my excise return for the month of June had to be taken into account. So as a bona fide SSC, where would I go, Lordships? And Lordship, the question, the dispute, they are not alleging anywhere that it was not eligible. So Lordship, when
No, they are categorically saying it is not eligible
when
for the purpose of getting the benefit under the transitional provision.
Lordship, when I see this
140.
from the angle of revenue neutrality, Lordships,
Hmm?
when I see this from the angle of revenue neutrality, Lordships, they say X amount you should have filed a claim of refund, and this refund was there.
Hmm.
I have utilized that amount in my GST, Lordships.
Hmm.
Where is the government at loss, Lordship, if I ask this question to myself?
Hmm.
Lordship, new regime, Lordship, first time GST came, nobody had clarity as to what has to be done. As a bona fide measure, we took it, they accepted it. Now 2018,
They
they...
also may not know.
Lordship,
But
that's
every time a person are becoming clever.
Lordship, I would on to Lordship.
We do one thing. We issue notice only for the
Lordship,
time being.
Lordship,
Let them file their reply or whatever may be. We could go for a quick disposal of the matter.
Lordship,
I think that is because the issue involved is small.
Lordship,
Irrespective of there being an appellate authority or that,
Lordship,
I'm not concerned on that.
Lordship,
Here, whether the question involved is whether the amount which you are entitled on the account of the PLA account would come within the ambit of the eligible duty
Lordship,
in terms with section
I
104.
would on to
I think that is the question which is involved.
Lordship, just the stay of the recovery procedure.
No,
Lordship,
no.
Lordship, I will be left with nowhere, Lordship.
You have already stayed there for another last 3 months.
Lordship, they had issued me notice, then there were vacations, Lordship.
What vacations?
Lordship, we were preparing for the writ to come. We were preparing the writ to file it, Lordship.
Where's the vacation?
Lordship, I am telling when
When
this
did you
letter,
file the writ?
Lordship, 6/9/23, the letter was issued. It
Then
was communicated after 14 days. Then they,
you
Lordship,
filed it on 18/12.
Lordship, we filed it now, but Lordship, it was under Lordship's kind consideration.
Sorry.
Lordship,
No stay.
Lordship, can I take your Lordship to 3 judgments of the
Not necessary.
Division bench of the Bombay High Court?
Mr. Counsel, judgments are always for the division bench and the Supreme Court to consider. For this, I don't.
Lordship, on the only issue of interim protection, Lordship, otherwise they will recover
What?
this. On the only issue of the interim protection.
Not
Unless your
necessary.
until your Lordship decides.
Interim protection is absolutely your discretion. I would have understood you have come immediately. You have come after 3
Lordship,
months.
112.
We'll have it immediately after the vacation.
Lordship, just one request, Lordship, last request, Lordship.
Hmm.
112 says, if had the tribunal been there, I would have to pay 20% and file an appeal. Lordship, let me deposit 20% and till that time, your
I
Lordship,
can only stay the penalty amount and the interest at best, nothing more.
Lordships,
You
Lordship,
pay, you
they
then
will-
you pay the
Lordship, they
central.
will recover this amount from they will attach 79, they will do my garnishing proceedings, Lordship. My writ would become infructuous because, Lordship, I have both the prayers. I have the prayers of interim stay as well as the...
Why any payment, if it is being taken away from you, will be
Lordship,
subject to the
today I
outcome?
don't have a unit at Assam. My unit has shifted already from Assam to Rajkot. Lordships, now they will be initiating garnishing proceeding, which we are envisaging. Lordship, it's a humble request, Lordship. Had the statute be there, 20%, they would have not recovered further. Lordship, I am ready to pay deposit 20% of the tax. 10% is already paid, Lordship. Lordship,
Sorry, Mr. Counsel. I can give you only one thing.
Lordship.
Interest question may be a question.
Lordship,
There might be some aspect of the matter as regards interest and all that might be.
Lordship, Lordship, they would start garnishing proceeding and until the time.
You see, the moment I'm staying the interest and the penalty, I think you are getting a benefit of already 60%.
Lordship, it is amount, Lordship, the tax amount, Lordship sees is 34 lakhs.
Understood. 34 lakhs and interest is 34 lakhs and the penalty is 4 lakhs. 4 lakhs.
94 lakhs.
So that is almost 60%. I'm staying it.
My Lordships, it would be a great trouble, Lordships. Had the tribunal been there, they would have taken 20% and a stay as per the enactment is there, Lordship. I am ready to deposit 20% of the tax, Lordship. Your Lordships may hear it any day. They may file a counter and I am ready to hear the argument, Lordships. But till that time, Lordships, the interim stay may be given. I am ready to deposit
Then
20%.
stay subject to 50% deposit.
Lordship, may kindly consider, Lordship, it's a closed unit. It's a closed unit.
And then I'm till now not satisfied with your arguments. Mr. Counsel.
Lordships, may kindly allow me to take to one judgment of the when in CBIC has given an affidavit. that this orders of appellate authority cannot be enforced. CBIC chairperson in Rostrum, India, there was a batch of petitions before the division bench of the Bombay High Court, wherein an affidavit of the CBIC chairperson was called as to what will be the effect of all the appeal orders until the tribunal is not formed. And the categorically it has been stated that because the time has been extended, the order in appeals cannot be enforced by the department. Lordship, kindly it allows me to take through to that judgment.
No. I've already seen that. You have
Rostrum,
enclosed
India,
it out there.
Rostrum, India.
Yes.
And
Enclosed
similar
out there.
rules
But
for-
that is the question. Then obviously, you want to say that only on the basis of that this court should not.
No, Lordship, I'm just telling the affidavit filed by the CBIC chairperson, who is the head of the department, Lordship.
So
And
then it
applies
is very
all
good.
across.
Then for that good reason, it is very good. An appellate authority order is already there. Where is the question of stay? Because they are not going to enforce it.
Lordship, had they not been enforcing, I would have not troubled your Lordship so much, Lordship.
Then do you know also why it is necessary to come back?
Lordship, kindly direct me to deposit 20% within 2
50.
weeks. Lordship, kindly direct. Lordship, kindly consider it's a close.
Okay, 55.
Lordship,
I was giving you 40%. You wanted 50, 20.
Lordship,
Then I made it
Lordship, kindly
50.
consider it's not a bad case, Lordship. Had it been a bad case, I would have not asked your Lordship.
Okay, you deposit 60%. Issue notice. Yes, madam, tell me. What case? Do they have a case?
May I please your lordship? Actually, we did not receive the service copy also yet.
What? You have not
Yes.
served copy? Whom
We
have
did
you
not
given?
receive.
Whom have you given? Where is Mr. Kyle?
He is not present right now in the court.
Huh?
He is not present.
Where is he? Yesterday also when I disposed of a matter, he was not present. Where is he?
He is actually not there due to his some personal difficulties, your lordship.
Have you taken the records of yesterday's matter? You are his junior.
Yes, your
Have you
lordship.
taken the records
Yes.
of the income tax matters?
Yes.
It is fine. Because they have already lost one record. Remember?
Yes.
Who has received? One has reserved for SC Kyle. 1812. Issue notice making it returnable on. When can you come? Final disposal
Last week of January, if your Lordship
Okay. on 30th of January 2024. 30. Miss, what's your name?
P. Khakolia.
So and so appears on behalf of all the respondents and accepts notice. Extra copies of the writ petition be served upon them during the course of the day. The petitioner herein have assailed the adjudicatory order dated 31/3/2022 passed by the respondent number who has passed? Superintendent,
Commissioner
Assistant Commissioner, who has passed?
The Joint Commissioner appeals, Lordship.
No, that is an appellate
Respondent
order.
number 2.
No, that is an appellate. I'm not. 31/3 is
322 is the appeal order, Lord.
no. Appeal order is
That is the
29/4/2020.
dispatch date, Lordship. That is the dispatch date.
What?
29/4/22 is the dispatch date.
Order. Where is the order of
Lordship, the original order is
adjudicatory?
at page 73, Lordship.
Challenge the order dated
Page 73, Lordship.
2/6/2020
Lordship.
passed by the
Respondent
Assistant Commissioner, passed by the respondent
3.
number 3, as well as the appellate order dated 31/3/2022 passed by the respondent number 2. by way of the instant proceedings. It is also taken note of that the second appellate forum as available under the Central CGST Act 2017 is yet to be constituted, and as such, the instant writ petition has been filed challenging the said orders. The dispute involved in the instant proceeding pertains to as to whether the amount which the petitioner would have received on account of the exemption notifications would come within the ambit of eligible duties mentioned in section 140 of the Central Goods and Services Tax Act 2017. From the perusal of the order, the appellate order, it is seen that the said that as per the authorities concerned, the said amount cannot be used as an input tax credit in view of the provisions of section 142 and more particularly subsection 8B of section 142 of the said Act of 2017. Taking into account the above, it is the opinion of this court that a question of law therefore arises for adjudication of the instant writ petition. Accordingly, this court is of the opinion that the instant issue is required, can be adjudicated in the proceedings under Article 2 to 6 of the Constitution. This court have also taken note of the submission of the learned counsel for the petitioner, Mr. So-and-so, who submits that as an interim measure, the communication dated 6/9/2023, whereby there was a direction for payment of rupees 33,69,271 as central tax, interest of an amount of rupees 33,69,271 and penalty of an amount of rupees 3,36,921 is required to be stayed pending disposal of the instant writ petition.
Interest on that amount, not the interest has not been calculated. This interest on that amount under section 50.
Oh, and interest on rupees 20 under section 50 of the state.
The 2023 is the board circular.
So the interest is 18%.
In 18%. Already 6 years passed.
Hmm?
6 years has elapsed, Lordship.
So it has already gone double, more
Lordship,
than.
Lordship, that is Lordship. Lordship on not that ground, Lordship. Kindly consider this.
You
Where-
therefore pray the principle, interest will stop.
Lordship, it's a close unit. Lordship, I will humbly submit, Lordship. It is
No.
on the merits, Lordship. Kindly educate, Lordships.
This court, upon giving a anxious consideration of the matter, stays the communication dated 6/9/2023 issued by the, who is this?
Lordship, respondent number 4.
By the respondent number 4, subject to deposit of the principal amount of rupees 33,69,271 within how much?
Give some consideration, Lordship. Lordship, I again go down, Lordship.
6th of January. Within 6th of January 2024. Full stop. The interest amount as well as the penalty shall remain state. Because then the interest will get arrested. It is, however, made clear that if the said amount of rupees 33,69,271, which have been directed to be deposited for the purpose of the stay, shall be subject to the outcome of the writ petition, and the petitioner herein would be entitled to the refund of the said amount if the writ petition is decided in favor of the petitioner.
Lordship, last, Lordship, 20%, Lordship, your Lordship, the statute provides. Kindly consider, Your Lordship. It will be, Lordship, your Lordship,
At the end of the day, you may find that this is the right order, because you see, I'll finish it off on the next date. The affidavit be filed by the respondents on or before 19th of January 2024. And the petitioner shall be entitled to file their reply by 25th of January 2024. So you see, then you just deposit, you'll get the money.
Lordship, it has fallen to Lordship's 50%, Lordship. Kindly make that.
50% of the total.
Lordship, Lordship, kindly consider, Lordship. 50% I'll deposit.
Sorry, Mr. Counsel, you deposit the entire.
Lordship's a humble submission. Lordship's, it's a closed unit.
Then you don't press for the interim.
Lordship's.
Then you don't press for the interim for the time. Then there is nothing mentioned. You will be able to evade everywhere. You see, the order was passed on 33/2022. They have not done anything. 6/9/2023. They have not done anything. Better off don't press for the interim.
Lordship, my case, Lordship, your Lordships have taken a note of all this submission. Lordship, some consideration is needed. Lordship, I would have not prayed so much, Lordship.
Sorry.
Had it been a working
Mr.
unit,
Counsel,
Lordship.
no. Sorry.
Lordship, kindly consider, Lordship. Last. May I please?
Yes.
I am in offense of two plot of land matter allotted by the Captain Craft. What happened, my lord, on 4/11/2020, my lord, some unknown person came to my land matter.
Your land has been acquired?
Acquired. It's not acquired.
Then?
I came to know that they acquired my land, but without giving any compensation, my lord, I am entitled to compensation, my lord.
The compensation under what?
For land acquisition, including therapy. I submitted a representation before the Deputy Commissioner also, my lord.
Your land has been taken?
I don't know, my lord, whether they're taken or not, my lord.
What? You don't know your land has been taken or not? First ascertain.
without any notice, my lord.
You have no right over the land.
Yes, I have the right, my lord. I annexed the document, my lord.
Hmm.
Annexed the tree, my lord. I am paying the revenue.
Where are you paying the revenue?
Annexed the tree, my lord.
Hmm?
Annexed the tree, my lord. Page 17, my lord.
Hmm. Which land we are concerned? Tag number?
Tag number 423 and 424.
424 belongs to one joint okolita.
Yes, I am the judge.
You are joint okolita. This is given under what? Rundown Act. What is that? Mr. Burwa? What is this act? Hmm?
I'm also not aware of. At the page 12, Lordship, the representation, there also they have stated that they came to know that NHAI has acquired some portion of land. Page 12, representation to the Deputy Commissioner.
Hmm?
Page 12, representation to the Deputy Commissioner, Lordship,
Hmm.
where they have stated that I came to know that NHAI has acquired some portion, approximately 2 kathas of total land. There also they came to know, they are not sure.
First,
No,
ascertain.
no such document has
This
been
is not the
annexed
court
also.
for finding out.
I representation maybe disposed of till
Representation disposed of.
yeah, till time of representation. In the plot of land, that I have a Pakka house. They want to demolish this house. When I protest, my lord,
Where is it? May you have mentioned?
yes, my lord, from the paragraph 3, my lord.
Your paragraph 5, you are saying that some unknown person.
Yes, my lord.
Well, you don't know. Nothing.
They told me
File a police case.
that if they told me that National Highway Authority appeared
Huh?
without giving any compensation, my lord, they did not no notice.
And the best part is this. The most important thing is this. These people came over to you on 4/12/2023. And on that day, they threatened you and say that this is the land which is being taken, acquired for the, what do you call, NHA. Fantastic.
On that day, my lord,
On that day, you submit the representation on 4/11, 1 month before. See paragraph 5 and the representation date.
my lord, they came to my land on 4/11.
You say that paragraph number 5, 4/12. Mr. Counsel, kindly do proper exercise. Don't file petition just for this. You have any case out there, go and approach the Deputy Commissioner for that. If it is the Deputy Commissioner has acquired the land or not. This is not for this court. You don't have to keep on filing petitions like this. If the land is being acquired, they will acquire it. Then they will pay you if you are there.
Yes, my lord.
As of now, your land has not been taken. When the land is taken, we'll see. Can you get the money before that? You don't know as to whether make inquiries and find out. The learned counsel appearing on behalf of the petitioner submits that he will file an additional affidavit bringing further additional facts as regards any inquiries being made by the petitioner in respect to the alleged acquisition of the land.
Statement.
Please the matter after 2 weeks. Huh?
Statement.
Fantastic. Please the matter again on 19th of January. File an affidavit, go make an inquiry and then find out. What is it?
41.
Why will the deputy commissioner otherwise here? The deputy commissioner has other work. Don't keep on just filing like that. What is this?
My lord, the petitioner has been marked as a deed voter, whereas no reference has been made yet, my lord.
Okay, you have a similar order.
Yes, my lord.
My order. Because similar order. Which district?
Walpara, my lord.
SP border.
Walpara.
Who appears for the election commission?
My lord.
And state coordinator, you, Mr.
No, my lord. State coordinator nowadays there is no standing.
No.
I am for respondent number 3 and 6, madam. 5 will be appearing by madam Borwa.
5 is it.
Yes.
Namkita Bhoyalu. Yes, councils give your name. Give your name. And voters list of which year?
17, 2007.
2007.
17.
17. It was 97 আছে 2017 বুলি আৰু in which constituency?
My lord, 38 number Walpara West.
Walpara West LAC. Huh? It not a suppose.
Apply.
Number 6 and 7 for admission.
Yes, what is this?
My lord, on pending matter, 2015, my lord, one fine day, the petitioner society found a barricade in front of their flag station. Flag station from where many buses were operated within the town. Now, on inquiry, it was found that there was an initiation by the concerned authorities in respect of the adjacent bus owner association, whereby their land was proposed to be taken up for construction of family court and other buildings, and for which their portion of land was barricaded, and against which they had filed a writ, the second writ petition, the other writ petition which is there, and in that this honorable court had passed an order of status quo, meaning thereby that since they were barricades, so the barricades would remain. Now, in that process, the barricades were extended in front of the flag station of the petitioner's flag station as well. Whereas, insofar as the petitioner's portion of land is concerned, or even the front of the flag station is concerned, in respect of that part of the land, there was no contemplation by the authorities then for construction of any family court building or anything of that.
What is this flag station?
Flag station basically is a place from where the buses fly, my lord, from where the buses start. That was starting point. And passengers, sheds, and all these things were constructed. Initially, this
That's a government land.
it's a khas land, it's a government land, but in respect of which we had applied for a provisional occupation certificate. That occupation certificate was given to us. Initially, we had been running the buses from a different place. On being compelled by the district administration, we were allowed to shift it to this particular place.
The district administration permitted you.
We were compelled to shift from the earlier.
Compelled is a different thing. But did they permit you to be there out that way?
In so far as being in that place, over there, we obtained a provisional occupation.
Did the district administration say that you cannot remain here, you go there?
Well, that communication was not. That is not.
But you went there.
Yes. And
you started your thing.
From 1994, we started. And in fact, there was a decision from the Traffic Advisory Board also of the concerned locality that we are carrying out with our functions to the satisfaction of the public at large. So it is in public interest that we
This is in Silchar city.
Yes, yes.
And what is this Kacha transport vehicle?
That is the other case. They are also a bus owner association. They also have a land adjacent to our land. Their land is much bigger one. Mine is only 12.
Both are government land.
Also in no. That is what their
Ours is not government.
Yours is a patta land. Yes. And they have put a barricade there. Now there is a barricade there.
There is a benefit, my lord. They are different. There is a government. Our is a patta land, but for trade purpose. For trade purpose. So it's a very activated national site. It's a very big thing there. After they have applied for this, they have been develop the land for traffic and for all. So there is of that of land by the park. So this is part that that's one is the part. The government has that the how the park get out. But it's not the park that
Allotment can.
Yeah, no. Settlement can.
Settlement can.
Settlement. But
Then?
that very next day, they are trying to capture one. So we submitted a different.
Okay, Mr. Borpujari. Now your turn. How did you cancel the patta?
No, fact of the matter here is that, my lord, these two associations, they were running the bus stands. It is just like, my lord, sort of a, my lord, like Adabari bus station sort of a thing. Now, that plot of land, my lord, that was, my lord, conditionally, my lord, given to them that you run private buses from here. By effects of time, it was found that it led to severe traffic congestion within the city. They were given an option that other lands are there. You go, you run it from there, because nowadays, my lord, due to traffic congestion in almost all busy cities, my lord, these bus stations are, my lord, made to operate, my lord, at the outskirts of, so that, my lord, it ease out the traffic. They remain reluctant. They objected to it.
Who?
My lord, these associations, petitioners.
Both.
Both. And this is how, my lord, the matter stands.
Understood. These all things I understand. That is, you have a right to do so and put them outside. There is no quarrel with that. It is on the question of public convenience and also the difficulties being faced or for administrative exigency you may require. Okay. But did you cancel the patta without the settlement without notice?
No patta was issued to them. Let them so. Let them so demonstrate.
Was there any settlement issue?
No. There was only conditional allotment. Let them so.
Yes,
If they say that
When patta was issued, we paid the premium. And originally it was allotment. 77. 2006, patta was issued.
Show me that patta
Yes, sir. At page 22.
of the writ petition,
Of the
2668,
Or it-
page 22.
22.
Yes.
And 23, 24, we have paid the premium about 22 lakh. Separate patta was issued to us.
Now, where's the patta?
This is the allotment, this is the settlement order. Man. Premium.
Is to order settlement of Sorkari land of so and so. Of 150%.
3 because 14
in
kathas of
so and
land.
so.
In Dag number 22.
Now, thereafter, this order has been passed, then this happened on 10 January.
Yes.
Your installment of payment of premium is so and so. Then you paid the premium.
Here we paid the payment. Total.
Then what happened?
Then, my lord, page 54, your lordship.
Huh?
Page 54. We installed, we have developed the land and put in stalls about 48 numbers at page 54. It has been reverted to the government. The reason is for the purpose for which it was given does no longer exist. What does it mean?
Yes. You see, kindly come to page 20. Page 20 is the recommendation for settlement.
Yeah.
And for trade purpose, subject to payment of 150% of the land value as premium on a condition that what is the condition? The association will have to arrange proper accommodation on the waiting of the passengers by constructing all weather structures.
Yeah.
They paid the premium.
Yeah.
Now see this order at page 54.
Yeah.
You now say that the land has been settled. Now you are also reverting it back.
No, yeah. Settlement, my lord.
Has been made.
Yeah.
You have not issued the patta. That is nothing to do out here. But here it is an admitted fact that the settlement has been made.
But settlement was conditional.
Conditional for what? Only for construction of all-weather structure. They have made the all-weather structure, and that is not the reason why. As you say, now it has become concerted, and as such, you don't want these people to be there. That cannot be the reason. How can you cancel this?
If my lord is taking up my lord WPC 3476.
2668.
268. If my lord may be pleased to come to the affidavit in opposition filed by the respondent number 4.
Who is respondent number 4?
That is my lord, the additional deputy commissioner Kasar.
Huh?
Additional deputy commissioner Kasar.
Yes, what does he say?
He does not say anything about
But
this.
Sri Abdul Rahim Sheikh, he is the deponent, my lord.
Yes, what does he say?
Also got it, my lord. That affidavit was, my lord, filed on 9th of September 2015. Where my lord will kindly come. My lord, may I read paragraph 5, my lord, with lordship's kind permission.
Yeah.
Some factual aspects of the matter needs to be clear. That the contents of paragraph 5 of the repetition of matters of record, so the deponent begs to state that the government in Revenue Settlement Department by letter number 1985 allotted a plot of government khas land measuring 3 bighas 15 kothas 12 chataks over by dark number so and so in favor of Asa Transport Vehicle Owners Association. That is the petitioner, subject to condition that they will improve upon the site with modern amenities and also to earmark some spaces.
No, Mr. Borputari, what is this? Now this person knows on what basis, because that is not the part of the order of settlement. Settlement says as on the condition that the association will have to arrange proper accommodation on the waiting of passengers by constructing sheds.
It is there in the latter part of the paragraph. Kindly see what is the background, my lord. Kindly see installing stalls for providing employment.
Where is the question of employment? Where do you bring the concept of employment? The concept of employment is completely foreign from the settlement order.
This is how
this is absolutely high-handedness.
No, this is how it happened. It progressed from 1985. Lordship, kindly see, my lord, to unemployed youth, which was the original plan of Silchar Municipal Board. It was the background, my lord, what culminated into issuance of the patta. That needs to be cleared before this court. It was also mentioned in the state government letter that the land would be reverted to government if not utilized for specific purpose within 3 years. So the aforesaid allotment order was issued by government in the year 1985, but actual possession was handed over for the quantum of land measuring 3 bighas 14 kothas by the order number so and so dated 5/6/2010 in pursuance of government letter dated 10/1/2006. In the said order dated 5/6/2010 regarding handing over possession, it has been specifically mentioned that the land should be utilized for the purpose for which it would be handed over, telling which the allotment will be cancelled and the land would be reverted back to its original status. In pursuant to the said order, the petitioners were utilizing the aforesaid land as a bus stand and other connected activities like ticket counter, shelter for passengers, etc. till the policy decision of the government transport department.
What was required was shelter for the passengers as per your allotment order.
I'm reading it. Lordship, kindly bear with me for a moment, my. In 2008 to shift all the parking stand from the, kindly see here, my lord, with a policy decision of government transport department in 2008 to shift all the parking stand from within Silchar town to outside town in order to.
Mr. Borputari, for having the Silchar parking stand from this place to that place, as I told you before, it is absolutely within your jurisdiction to do so. I'm not on that. But the question is, how do you cancel it on the basis of this time?
So far as patta is concerned, my lord, issuance of patta, my special submission will be, my lord, that formal patta has not yet been received.
Not necessary. Yeah. Formal patta you have not done. For that, Mr. Das, you have asked for compensation? Or should I import the law of constitutional thought and impose on the amount upon this particular, what is his name? Abdul Rahim Sheikh.
Abdul Rahim.
And to deduct it from his salary. I think that is the best option.
Yes.
This is absolute high-handedness on the part of the authority.
Yes.
This court will strike down this thing. This is not done.
There were a series of litigations.
Let it be, whatever may be.
No,
but this is not the thing which you do. I'm not on, Mr. Borputari, the question of having administrative inconvenience, the difficulties as regards having that as a bus stand, absolutely you can do, whatever may. But you can't cancel this settlement in this manner. No. And that too, when you on affidavit, you say that there has to be a shelter. They have made the shelter.
Yes.
Where do you bring in all these things that unemployed youth? Where is that document, Mr. Das?
Where?
That document?
Which document?
You remove this. Other people, it is okay, but this you can't. Yes, this one, page 54.
Page 54.
You have challenged that, no?
Yes.
And what are the impugn order 28.4? And what 28.5?
54-55.
For reversion of so in
there is a constitutional order.
We set aside these two.
Yes, sir.
But as regards the decision to remove from there to any other place,
Yes,
this
yes, yes,
court
yes.
is-
No, no problem. We have come here for the cancellation of the settlement.
and you are not asked for any compensation
It seems
for
it
the
is not
troubles
there.
they have to pay.
Lordship will kindly record my submission. My lord. Lordship, my submission may be the fallacious.
According to what submission?
My lord, that they are not settlement holders. They are not settlement holders.
On what basis this?
Because formal patta has not been issued.
But your lordship
The
will
lease
see
has to be there.
separate
In
patta was granted.
the terms of lease will have to be there. And the terms of lease is there, my lord, in that affidavit, which my lord, I am reading, my lord. There, my lord will kindly come to page 19. Page 19. Page 19. It is because the lease is always conditional. If lordship presumes it to be a miyadi patta, periodic patta, then there has to be terms of lease. Seen the government so and so by which government directed to hand over possession of measuring 3 figures so and so under Moses so and so to Fasa transfer and also correct the land records and issue patta after realization. Since the premium has been realized in full, the possession of land may be handed over.
So you pay them the premium? You are ready to pay the premium back?
No.
No, Mr. Borpujari. You give an undertaking that you pay the premium at 50 times the amount. You are ready?
I will have to take instructions.
No. Today. It matter can't be after 1 o'clock it is finished. Don't spoil the time of this court unnecessary and make this type of argument. I'll record your submissions and negative it. Don't worry. But I will say about the high-handedness of the authority. And as such, some compensation in some form has to be given. They don't want it, but to the legal services authority. From the salary of this person, from the deputy commissioner.
May not get able to that extent.
No, yes, I am. Because this is absolutely high-handedness. You want to do okay, but how can you cancel? I never heard of. Tomorrow you may get anybody's land. You can do. And are you saying that the governor's decision, the government's decision has no meaning? And you are appearing. You, Mr. Borpujari, are you appearing for the deputy commissioner or the revenue department?
The revenue department.
Now, and this settlement order has been passed by the revenue department. And are you saying that the revenue department direction, the deputy commissioner need not follow? No, I will conduct it. If the moment you are saying that, that means the deputy commissioner did not follow and rightly done so. Are you saying that? By not issuing the patta, in spite of receiving this amount? Mr. Borpujari, don't make this type of submissions. We don't expect such submissions from you. What is this type of submissions? You are appearing for the revenue department. The revenue department says that the governor of Assam has recommended for this. And okay, the recommendation is there, and thereupon you have received the amount, done everything, they were doing everything, and now you are coming with all these things, and the deputy commissioner says, who is the governor? I don't care the governor, I don't care the revenue authorities. Then stop your department out there. My goodness. Don't make this type of submissions. I'm not going to appreciate such submission.
On record, there is no patta.
Why is it required?
Because patta.
When the order categorically mentions that it has been settled, see the order which have been impugned. The land has been settled with them, but we are reverting it back for not utilizing. Then even your the other department accepts, but the revenue department does not. Are you not submitting anything? Are you not submitting? Your submissions clearly disregard the efficacy of the revenue department.
No, that is not the intention of my submission.
Absolutely. That I am going to record. That the revenue department has nothing. That will be your submission. The revenue department's communication need not be followed by the deputy commissioner. That is your submission.
I have not submitted.
No, that it should be your submission,
My
because when
submission
you are saying,
No, Lordship may record anything, but my submission is clear. I had submitted that there is no material on record. They have not received the patta, the final patta.
why is the patta required?
That Lordship will interpret my.
Not required to interpret all this.
That is my submission. My plain and simple submission is that since there is no patta on record, in my view, subject to Lordship correction, they are not.
That is for the Revenue Department submission. Heard Mr. B. C. Das, the learned senior counsel, assisted by so-and-so. Learned counsel for the petition. I will take your case separate. And Mr. R. Borpuzari. R. Borpuzari. Appearing on behalf of the Revenue Department. And Miss, who is for Deputy Commissioner? Mrs. Yuda, appearing on behalf of the Deputy Commissioner, Kachar. The instant writ petition has been filed challenging the orders dated 28/4/2015 and 29/4/2015 issued by the Deputy Secretary to the Government of Assam, Revenue and Disaster Management Department, and the Deputy Commissioner Kachar, respectively, and all subsequent actions taken in pursuance thereof. From a perusal of the writ petition, it reveals that the petitioner herein is a registered society under the Societies Registration Act 1860, having a registration number being 54/1945-46. In the year 1972, witnessing speedy and sudden growth of the urban area under the Silchar town, and with the increase of population and consequent number of buses also increasing, the government, by the order number SRS.118/77-78/8-A, dated 9/10/1977, allowed the petitioner association to use a fallow, deep, marshy government land near BRTF camp at Trunk Road, Silchar, for a period of 6 months. The said right to occupy the said land was extended from some time to time till in the year 1985 till the year 1985. It is also seen from a perusal of the petition that the petitioner association developed the land by outfilling and made constructions not only for the purpose of ticket counter, but also for garage and other commercial shops necessary to cater to the needs of the passengers. In the year 1985, at the request and advice of the respondent number 4, that is the Transport Department of the Government of Assam, the Land Advisory Committee allotted a plot of land measuring 3 bighas, 15 kathas 12 chataks covered by dock number 2678A and 2678B by order dated 17/6/1985 on certain conditions to the effect that the petitioners association should provide employment to local unemployed youth. In compliance of the said requirement, the petitioner association made boundary wall on all the three sides of the land by further developing it, and also made construction of 3,500 square feet of the building over the said land for passengers shed, canteen, the office of the petitioner association, ticket counter, etc. after taking permission from the Silchar Development Authority on 5/7/1993. The record further reveals that by their communication dated 10/1/2006, the Joint Secretary to the Government of Assam, Revenue Settlement Department, addressed to the Deputy Commissioner Kachar Silchar, informed the latter that the Governor of Assam was pleased to order for settlement of the Sarkari land measuring 3 bighas 14 lechas covered by dock number 2678A and 2678B under Silchar Town Moza, Porgon, Porgonah, Porgona, Barakpur, with the petitioner association for trade purpose, inverted comma, for trade purpose to payment, subject to payment of 150%, rupees 150% land value as premium on condition that the association will have to arrange proper accommodation on the waiting of passengers by constructing all-weather structure, inverted comma close. The land value was fixed at rupees 4 lakhs per bigha. Before moving forward, this court finds it very pertinent to observe that in the said communication, it was duly informed that the Governor of Assam had ordered for settlement of the government land in favor of the petitioner. And it was not merely a recommendation for settlement of the land. Thereupon, the record further reveals that the petitioner paid the entire premium in 7 installments as permitted, which the respondent authorities, more particularly the Deputy Commissioner Kachar, had duly accepted without any objection. The record further reveals that that there were various litigations filed by some third parties on the aspect of shifting of the parking stands outside the town. Full stop. It is also relevant to take note of that this court, by an order dated 26/2023, had dismissed a writ petition being WPC number 3020/2012, along with other writ petitions, observing that the shifting of the parking stand does not mean putting an embargo or restriction on the plying of city buses, taxis, etc. on the roads of the Silchar town. It is also pertinent to mention that the respondent number 4 had denied the entry of city buses in the Silchar town by the memo dated 30/6/2014. This was challenged by the petitioner in a writ petition which was registered and numbered as WPC number 5059/2014. This court, by an order dated 26/9/2014, directed the respondents not to put any restriction in the entry of city buses in the Silchar town. What has happened to this writ petition 5059? Madam, you will know. Is it pending?
No.
Dismissed?
It was dismissed against the order of the filed one is active.
So there is no effective order against it. Okay.
The writ appeal number is, my lord.
It has been stated at the bar that the petitioners could not, the said litigation, however, it has been stated at the bar that the said litigation, however, culminated without interference to the communication dated 30/6/2014 passed by the respondent number 4. However, the said proceedings culminated only on when did it finish?
My lord, the order dated 23/8/22.
Only culminated in 3/8/2022. 23/8/2022. Full stop. Next. Be that as it may, taking into account the order passed by this court on 26/9/2014, whereby there was a direction upon the respondents and more particularly the transport department not to put any restrictions in the entry of city buses in the Silchar town. in WPC number 5059/2014, the respondent authorities, more particularly the Revenue Department, as well as the Office of the Deputy Commissioner, Kachar, in order to circumvent the orders passed by this court, passed the impugned orders. The first order was passed by the Deputy Secretary to the Government of Assam Revenue and Disaster Management Department on 28th of April 2015. The contents of the said order being very pertinent for the purpose of adjudication of the writ petition is quoted hereunder. Sir, Arobra, Landole. Sir, I am directed to so and so, original status, as we have page 54. From the above quoted order, it would be seen that there was an approval by the state government for reversion of the land measuring 3 bighas 14 lechas, which was settled in favor of the petitioner. 14 kathas, which was settled in favor of the petitioner to its original status of government land, as the purpose for which the land was allotted and subsequently settled with the association did no longer exist. Accordingly, the Deputy Commissioner, Kachar, was directed to take necessary steps for record correction and take over the possession of the land. It was also mentioned that a consultation be carried out with the petition association regarding the terms and conditions oblique the compensation to be paid to them and the premium to be refunded on reversion of the land. It is further seen that thereupon, on the basis of the said communication dated 28/4/2015, the Deputy Commissioner Kachar passed the second impugned order on 29/4/2015. Stating about the contents of the order dated 28/4/2015, and further that the Assistant Settlement Officer, Sodor Circle, was directed to take over the possession of the land and to correct the land records accordingly. It is also relevant to mention that in the said communication, the superintendent, the said order, in the said order dated 29/4/2015, the Superintendent of Police, Kachar Silchar, was also directed to provide adequate police force at the time of taking possession of the land to maintain law and order. Full stop. The petitioner thereupon submitted representations. However, the respondent authorities turned a deaf ear towards the same, for which the petitioner herein was compelled to institute the instant writ petition on 7/5/2015. The record reveals that by an order dated 11/5/2015, this court issued notice and further directed that the status quo be maintained as regards the possession of the land, maintain status quo as on 11/5/2015 with regard to the land involved in the case. From the record, it is seen that the respondent number 4 had filed an affidavit in opposition through the Additional Deputy Commissioner Kachar that an affidavit in opposition was filed by the Additional Deputy Commissioner Kachar for and on behalf of the respondent number 1. Although in the said affidavit, it was wrongly shown that the said affidavit was filed on behalf of the respondent number 4. Respondent is transport. 4.
Transport has been already deleted by the order dated 11/5.
1 is deleted.
1 deleted. Order 11/5.
No, anyway, no. Here why I'm saying this affidavit, what he said, an affidavit in opposition filed by respondent number 4. It is being done by Abdul Rahim Sheikh. I am presently serving as the Additional Deputy Commissioner Qatar. Then by hand, somebody has written that I have been duly authorized by the respondent number 1. What is this?
Here in my copy, it is respondent 4, my lord. I don't know.
I don't know. For you, it is different. Here it is. Yeah.
Typological, but that remains, my lord. That he is
Somebody has signed it. Who is this? Monisha Bora.
May take it place for the deputy commissioner's affidavit on behalf of deputy commissioner.
An affidavit in opposition was filed by one additional deputy commissioner,
Yes, my lord.
Kachar Silchar,
Yes.
stating that he had been authorized by the respondent number 1. In the said affidavit, this court finds it relevant to take note of paragraph number 5. In the said affidavit, in the said paragraph, the said additional deputy commissioner Kachar have mentioned about the order dated 17/6/1985 regarding allotment of a plot of land measuring 3 bighas, 15 lechas, 15 kathaks, 12 chataks, covered by DAG number 2678A and 2678B of Moza Silchar town for Porgona, Barakpur in favor of the petitioner, and the conditions mentioned in the said order. It was also mentioned that though that said allotment was made in the year 1985, but the possession was handed on 5/6/2010 in pursuance to the government's letter dated 10/1/2006. On the basis of At the cost of prolixity, this court finds it pertinent to take note of the communication dated 10/1/2006, wherein the condition incorporated for the purpose of settlement of the land in favor of the petitioner was to arrange proper accommodation on waiting of the passenger by constructing all-weather structure. In the perspective thereof, if this court now takes note of the said affidavit filed by the additional deputy commissioner, it would be seen that it was an admitted fact that the petitioners were utilizing the aforesaid land as a bus stand and other connected activities like tickets counter, shelter for passengers, etc. Till the policy decision of the government transport department in the year 2008 to shift all parking stand from within the Silchar town to outside Silchar town in order to ease traffic congestions and for larger public interest and installation of the ISBT, Ramnagar. Therefore, a conjoint reading of paragraph number 5 of the affidavit filed by the additional deputy commissioner, Kachar, with the communication dated 10/1/2006 would clearly show that the petitioners herein were utilizing the said land for the, in terms with the condition prescribed in the communication dated 10/1/2006, that is, to arrange proper accommodation on the waiting of passengers by constructing all-weather structure.
Lordship permits, my lord, with due apology, my lord.
Anything you have to say, say in the division bench.
No, my lord, the part of the report, my lord, page
But
29 of that affidavit, the genesis. of
why
the
we
entire
should not
dispute.
initiate contempt?
This is the genesis of the entire dispute, page 29. Why?
Not necessary. All these are for division bench. The record further reveals that an affidavit in opposition was also filed by the respondent number 2. That is through the Joint Secretary to the Government of Assam Revenue and Disaster Management Department. In the said, in paragraph number 9 of the said affidavit, it has been mentioned that in view of the decision taken by the government to shift the parking stands outside the city town, the land owned and possessed by the petitioner appeared to be of no use to them. And the land was also lying vacant. And therefore the DC requested the government to revert the said periodic patta land to its official status. It is under such circumstances that the government in the Revenue and Disaster Management Department wide letter number RSS/1224/2005/82 dated 28/4/2015 conveyed its approval to the proposal of the DC for reversion of the land measuring 3 bighas 14 letters, which was settled in favor of the petitioner association to its original status as government land, as the purpose for which the land was allotted and subsequently settled with the petitioner association did no longer exist. It was also mentioned that the government also directed the DC Kachar to take necessary steps for record correction and take over the possession of the land. And also, the DC was directed to consult discuss with the association regarding terms and conditions, compensation to be paid to them, and the premium to be refunded on reversion of the land. It is, however, very pertinent to mention that though these affidavits were filed in the year, affidavits filed by the respondents in the year 2015 and 16, there is no mention whatsoever as regards any consultation or discussion made with the petitioner association, as was directed in the communication dated 28/4/2015. In the backdrop of the above, let this court therefore take note of the respective submissions of the learned counsels for the parties. Mr. B. Siddharth, the learned senior counsel, submits that the land was allotted, was settled by the governor of Assam by the communication as communicated by communication dated 10/1/2016 6, on the condition that the petitioner association is required to arrange proper accommodation on the waiting of passengers by constructing all weather structures. He submitted that from a perusal of the affidavit filed by the respondent by the said additional deputy commissioner, the deputy commissioner Kachar, it would be clear that it is an admitted fact that the petitioner had constructed the shelters for the respond for the passengers, amongst others. Further to that, the learned counsel submitted that this action on the part of the respondent authorities to pass the order of 28/4/2015 and 29/4/2015 is nothing but a vindictive attitude adopted against the petitioner association on account of the order obtained on account of the order passed by this court in WPC number order on account of the order dated 26/9/2014 passed by this court in WPC number 5059/2014, whereby there was a direction issued by this court not to put any restriction in the entry of city buses in the Silchar town. The learned senior counsel submits that as the responding authorities were not in a position to get the order vacated by legal proceedings, they have resorted to such actions which on the face of it amounts to an obstruction to the cause of justice. He further submits that such things not only is absolutely illegal on the face of it, as is on the face of it illegal, but also strikes against the rule of law. Anything more, Mr. Das?
Yep, this is the high-handed action. At paragraph.
He further submits that this very aspect would show the high-handedness of the respondent authorities to take the law in their hands.
Yes.
And the orders passed by this court can be circumvented at their own will. Anything more?
That's
Who was the deputy commissioner then? Who has passed the order and the deputy secretary?
They have called for
Deputy Secretary was, my lord, page 20 of that affidavit. Page 20, 1C dash.
Is there?
No, he is no longer in the department. He is no longer in the department.
He is no longer in the department.
He has superannuated, my lord, perhaps 4 years back, 4 years ago.
Both.
Deputy Commissioner.
By the time I finish the judgment, you get the instruction. If they are there, then I'll initiate disciplinary inquiry again.
No, he does, he is there. He is not there, that is for sure. But so far as Deputy Commissioner is concerned, I am not aware, my lord.
The learned senior counsel further submitted that a perusal of the affidavit filed by the respondent number 2 would show the reason why the order dated 28/4/2015 was passed. Inasmuch as per the affidavit of the respondent number 2, the land, respond number 2, the decision to move the decision in the respond number 2, the district the decision of the district administration asking all vehicle owner associations in the district to move outside the Silchar town area have rendered the land vacant, and as such a proposal was sent by the deputy commissioner requesting to revert the periodic patta. Land to its original status. The learned senior counsel submitted that at that relevant point of time, the order dated 26/9/2014, passed in WPC number 5059/2014, was in existence. And as such, this could not have been the basis for taking the decision, and as for which the learned counsel, senior counsel submitted that actions were taken not only suffers from malice in fact, but it's also a case of malice in law. The learned counsel, therefore, referred to the judgment of the Supreme Court in the case of S.R. Venkataraman versus so reported in 1979 to SCC page 494. Now come to Mr. Anything else? Okay. Mr. Arbor Pujari, on the other hand, appearing on behalf of the Revenue Department, refers to the affidavit filed by the additional deputy commissioner, and more particularly to paragraph number 5. This court is shocked and surprised to take note of that there is a submission being made to the effect that on account of the periodic patta having not been issued, there is no right on the petitioners had no right, even though the governor, as per the communication dated 10/1/2006, had settled the land in question in favor of the petitioner. This court is further shocked and surprised at the submission made by Mr. R. Pujari to the effect that there was no periodic patta issued, although the respondent number 2 for whom he appears categorically mentions in paragraph number 9 of his affidavit that the DC had requested the government to revert the said periodic patta land to its original status.
And the entire decision is based on, my lord, page 29 of that affidavit. That is what I was trying to draw my lord's attention. This is the genesis of the entire dispute.
Everything is understood, but you couldn't have done that. I said to you, I have nothing to do as regards the shifting. I'm not touching it. But the only thing is, you could not have done this in this manner.
But my submission is...
So don't make that submission about the periodic patta business. These type of submissions doesn't look good on a person of your status.
No, my lord, that is
and not before this.
But,
you can make this type of submission anywhere. Not here.
No, page 29.
I understand that. Therefore, I told you, shifting you want to do. You go ahead. I'm not on that. You have a right to shift anywhere. You can even say that we are not going to have a bus stand in the Silchar town or outside also. All these people, let them take a taxi and go anywhere. You go to China, you would see none of the high-speed trains are there within the vicinity of 80 kilometers of the city. All are outside. So this is very much permissible, taking into account the traffic congestion. But the high-handedness is writ large. Now, who is appearing for the DC? Yes, what do you have to say? High-handedness? Mrs. Yudas, the learned additional senior government advocate, appears on behalf of the Deputy Commissioner, Sir Kachar, and submits in the line with the affidavit so filed by the additional Deputy Commissioner, Kachar, dated 9th of September 2015. You, what is your submission?
I am not a party. Honorable Court of Strike out 9.
Okay.
While order dated 11/5/2015.
Miss MD Bora, the learned counsel appearing on behalf of the Transport Department, submits that the State Transport Department was earlier a party to the instant proceedings, but however, subsequently the State Department has been struck off, for which the State Department has nothing to say in the instant proceedings. Having perused the materials on record and heard the learned counsels for the parties, the issue which arises out here is as to whether the respondent authorities could have, in the circumstances of the case, cancelled the settlement which have been made in favor of the petitioner association, and thereupon further by the association in the manner which had been done by the impugned orders. This court, while narrating the facts supra, had categorically observed that the communication dated 10/1/2006 issued by the Revenue and Disaster Management Department categorically mentions that the said land, that the governor had settled the land in favor of the petition association. And the condition for settlement was only that the petitioner arrange proper accommodation on the waiting of passengers by constructing all-weather structure. Full stop. If this court takes note of the communication, impugned communication dated 28/4/2015, it would be seen that the reason why it had been the settlement was cancelled as the purpose for which the land was allotted and subsequently settled with the association did no longer exist. Full stop. If this court now takes note of the affidavit filed by the respondent number 2, it is mentioned that on account of the Deputy Commissioner informing the Revenue and Disaster Management Department that that in view of the decision taken by the respondent authorities to shift all commercial vehicles outside the town of the Silchar town, the settlement, the periodic settlement made in favor of the petitioner should be cancelled and reverted back to its original status. Full stop. However, if this court takes note of the affidavit filed by the respondent number by the additional Deputy Commissioner, it would be seen that the allotment was to be cancelled on account of the condition on the ground that the allotment of the land to the petitioner was not perpetual, and the same was allotted with the condition that as and when the purpose for which the land was allotted would cease to exist, the land would revert back to its original status as the government cast land. The order of settlement, as already referred, dated 10/1/2006, does not mention in any manner that the land would revert back to the government. As and when the purpose for which the land was allotted would cease to exist. Yes, it is true that the initial allotments were made on 17/6/1985 mentioned the said condition. But the said condition ceased to exist with the allotment settlement letter dated 10/1/2016. 6. And as such, the basis on which the respondent authorities have cancelled the settlement made in favor of the petitioner is, in the opinion of this court, arbitrary, unreasonable, and amounts to a high-handed action on the part of the respondent authorities. The rationale behind the opinion of this court that the action of the petition, the respondent authorities are high-handed is on account of the fact that when there was an order passed by this court in WPC number 5059/2014 dated 26/9/2014 that the respondent should not put any restriction in the entry of city buses in the Silchar town. The respondent authorities, instead of taking the legal course for vacating the said order or filing an appeal, took the step of cancellation of the said periodic patta issued to the petitioner and taking over the possession so that the petitioner cannot further agitate that its buses would ply from the Silchar city. This, not only in the opinion of this court, is a case of high-handedness, but it's also a case of malice in law, and coupled with a case by which the rule of law has been duly affected. Under such circumstances, it is therefore the opinion. Moving forward, this court also finds it relevant to take note of that when the land has been settled in favor of the petitioner, and all the respondent authorities duly admit that the land was duly settled, the question of not issuance of a patta has no meaning. And as such, the submission so made by the respondent, by the learned counsel, Mr. R. Pujari, for the Revenue Department, is not only misconceived, but it goes against his own department. Further to that, if a land has been duly settled, then due rights accrue upon the petitioners over the said land. And this right cannot, under no circumstances, be taken away in the manner in which has been sought to be done by the respondent authorities. The rights under Article 300A have been affected, the rights of the petitioner, association under Article 30A, have been thrown to the wind by the respondent authorities in the most arbitrary and unreasonable manner. Taking into account the above, this court therefore sets aside the order dated 28/4/2005 to 15 issued by the respondent, by the Revenue and Disaster Management Department, as well as the consequential order dated 29/4/2015 passed by the Deputy Commissioner Kachar. Mr. Mahajan, you are in possession. Mr. Das, you are in possession. Okay. This court further makes it clear that under no circumstances the respondent authorities shall disturb the possession of the petitioners without taking the law without following the due process. cost. This court further takes note of another very vital aspect of the matter, which is that the petitioners have been unnecessarily dragged before this court on account of the high-handed action of the respondent authorities, more particularly the Deputy Secretary in question, who issued the order, as well as the Deputy Commissioner of the district in question. They have retired. So you deduct this from the pension.
Deputy Secretary, my lord, the Deputy Commissioner, I am not aware, my lord, but the Deputy Secretary retired.
So deduct them from the pension.
Direct.
Yeah. This court in the facts of the instant case imposes a cost of rupees 50,000 upon the respondent authorities to be paid, jointly shared by the Revenue and Disaster Management Department as well as the Deputy Commissioner, Kachar, which shall be paid to the petitioner within a period of 4 weeks from today. Footstop. This court leaves it to the absolute discretion of the authorities concerned as to whether to recover it from the erring officer for whose. No, we won't put that because they did it under their directions. No? But imposition of cost is required.
They did it under the direction of
Huh?
They did it under the direction of higher authorities.
No, that it is not required. Imposes a cost of rupees 50,000 to be paid to the petitioners within a period of 6 weeks, 4 weeks from the date of the instant judgment. A copy of the instant order be furnished to Mr. R. Bapuzari as well as Ms. Udas, appearing on behalf of the Revenue and Disaster Management Department as well as the Deputy Commissioner Kachar for effective compliance as regards the payment of cost as directed herein. And then, yes, what was your case? One line, huh? Before parting with the record, this court makes it clear that this court had not expressed an opinion as regards the plying of vehicles or shifting the plying of commercial vehicles in the city of in the Silchar town, or as regards the decision of the respondent authorities to shift the plying of vehicles outside the city, the Silchar city. We'll take it up too.
Congratulations. Exactly, मैं भय देखाई नहीं
8 to 7 of which 4 to 6. 8 to 7 of 7. 7 to 6. 6 to 2 बजा लो.
Wait a matter, say connected matter.
assisted by yes na. Assisted by yes.
मैं निवेदन करके हम मीटिंग में दबा के लगेगा नहीं कुछ डिपोट ठीक है
They have done
For judgment, WPC 5110/2013.
Mr. Counsel, here the writ petition was filed for two purposes. The first is for holding the sport e-auction scheme 2007 as violative and to be struck down. This court finds that there is an e-auction scheme of 2022 which has already replaced the 2007 thing. And as such, for this court to go into a thing which is not there in today would not be proper. So this court therefore has not gone into that aspect. Now, the second question is as regards the petitioner number 1. Petition number 2, 3, and 4, they have already asked for adjustment. So the question does not arise. Now, the petitioner number 1 has asked for compensation at the rate of 500 rupees per metric ton. This court has negated it on the ground that this court under Article 2 to 6 cannot decide, taking into account that there was no mention out there in the scheme to the effect that this would be the compensations to come within the ambit of Section 74 of the Contract Act. However, for 73, one has to show the loss suffered, and the loss suffered cannot be decided out here under Article 2 to 6. However, as regards the fact that the scheme says about no interest on the EMD, but does not say anything about the coal deposit. So the coal deposit which was made, the coal value which was deposited minus the EMD, whatever amount, and for that particular period, there will be an interest of 7.5%. Only on that. For that, I think 45 days or something. 45 or 20 days.
No, 6.
Yes, what is your case?
Well, my case is on a slightly different footing. I don't have as good a case as item number 7. In item number 7, there was settlement, then there was cancellation. In my case, pursuant to the cancellation of item number 7, cancellation of settlement of item number 7, barricades were put in front of the flag station, as we call it. And in putting the barricade, that barricade extended even to the flag station of the petitioner's part of the land, which measured 12 katha.
No, not your land.
No.
It's the government land.
Yes. My lord, here, my lord had asked.
No, what is wrong with that?
My lord, I'll just come to that, my lord.
No, first and foremost, they have already taken a decision to the effect that they are not allowing you to have their vehicles in and around the city of Silchar city.
My lord.
They want all these people to be removed outside the Silchar city.
My lord.
And what is wrong with it?
My lord, here, one thing is, in so far as.
Have you been evicted or not?
No.
Oh.
I have.
When are you evicting?
For now, my only prayer.
Madam Yudas, when are you evicting them? Evict them.
Before eviction, my lord, only thing that I expected. Or
where about the barricade?
My lord,
you are liable to be evicted.
My lord, your lordship kindly takes note of a couple of documents, my lord. If your lordship kindly takes note of the couple of documents which had actually been having the sanction of the district administration. Page number 17 is a minute of a meeting which was conducted under the chairmanship of the district commissioner, the additional, in fact, the deputy commissioner.
No, that might be at best, Mr. Chakraborty, it may be at best a question of permission being granted to be in occupation, which will come within the ambit of Rule 16. But nothing more than that. They may at all revoke the permission. And as of now, there is no use. And as of now, there is no also plying of vehicles within the city of Silchar. So then matter ends. You should be happy.
What I am on to is that here, in so far as
only thing I think you should do is withdraw the instant petition, so that this court does not pass an order to that effect that you should also be evicted.
Eviction part is something that perhaps will be a prerogative of the authorities, and being a government land, I'll
No, because I will record her submission and they will take step for eviction.
something that as of now is perhaps
So you don't have a right on the land. Where's the question of barricading? They will put whatever barricades they feel like.
but the fact remains.
Unless this is a land which is there of the government, and the barricades is also put in and around the road. So it will be a roadside, and as such, they can very well exercise the powers under Rule 18.
But my lord, here in doing so, the action was pursuant to the cancellation of the settlement in item number 7.
That is okay. That is okay. But as of now also, this court have not interfered with the decision to remove it outside Silchar city. This court have not.
Absolutely.
It is only in respect to this. Now, where is the question of not putting a barricade?
But my lord, in so far as we being allowed to fly the vehicles.
Now you can't.
Now we can't.
Then what is the point? You want to evict them?
Yes, my lord. Because now, my lord, authority has taken the decision, my lord.
You want to evict? Do you want the land, I suppose? You don't want the land.
That's it.
My lord, if they want the land,
They will evict you.
they will evict me.
Okay.
But till then, what happens to the ticket counters, the passenger shed which we have constructed? And we have-
As of now, there is no vehicle flying out there.
My lord,
Then where is the question of why are you still agree with the barricades?
my lord, this is something that we have been active since 2015.
That was okay,
So we came
2015.
before
Now it is different.
Now, only thing, my lord, now that in item number 7, the settlement in so far as the adjacent land is concerned, that has been revived. Now,
But they cannot fly there.
they cannot fly there. Now, my lord will kindly see in so far as otherwise flying of the vehicles over the town is concerned. To that effect, there's a judgment of this honorable court that has also been annexed in one of their affidavits, which says that there is no impediment in so far as flying of the vehicles over the city is concerned. But when it comes to flying from that particular station, now to that effect, my lord, in my case, there has been an affidavit filed by respondent number 4, where it says that there was a policy decision of 15. Well, they have stated they have referred to 15th July 2008. If your lordship takes up the affidavit filed by respondent number 4, at page number 3, paragraph number 5, they have.
I've read it.
Yes. So
Yeah.
here, what they have stated is that my lord, that with regards to the contents of paragraph 4 of the writ petition, the humble defendant begs to state that the resolution taken in the meeting dated 28 to 2000 lost its spirit due to the issuance of a subsequent notification by Transo dated 15 July 2008 by the Commissioner and Secretary to the Government of Assam Transport Department for the purpose of easing out traffic congestion.
So your submission at best could be that whatever may be, till I am in possession,
Yes.
they should not disturb me without following due
Yes,
process.
that is what my submission.
That's all.
That's all, my lord. What else? What other right can I exercise?
We'll follow the procedure.
So they will. They want to evict. They will follow it.
And one more thing, my lord.
You want to evict? They want to evict.
Well, look, their saying is good enough for me to prepare for my future itinerary.
Huh?
Their saying is good enough for me to prepare for my future itinerary for now, my lord.
Yes.
But my lord, just one thing, I was just referring to this paragraph to just point out before your lordship that this particular policy decision that they had taken, pointed out, that does not apply to the petitioner society, because when it comes to shifting, that aspect, my lord, is as per their affidavit is in respect of operation of buses which are of interstate, interdistrict, and long distance are concerned. So for those buses, the shifting is contemplated outside the town to interbus.
What do you do?
We are minibus
Where?
within the town. We are neither interstate, we are neither inter-district, nor long distance bus services. So it perhaps crosses my mind at times that for local buses, unless and until, my lord, there is a decision in so far as putting a complete impediment over flying of local buses within the city, which is not the case. Buses are flying. So for local buses to start in the morning and stop in the evening at some point of time, if the station is to be in a place that has that they have suggested to be interstate bus terminus. That, my lord, for some my lord, reason perhaps.
You don't have a right to remain there.
That is there. That aspect is a different aspect.
That is the most important aspect.
To that effect, my lord, if I may be allowed to point out that I had applied for patta over that portion of land since my.
That they are not going to give it.
Now they are saying they will evict me. Forgetting about giving me patta, they are ready to evict me. In fact,
So better of withdraw.
my lord, I'll only take, my lord, that part of your lordship's indulgence, that until a due process of law is.
Then you are inviting them. The moment I pass that order, they will do so. That is why I am worrying. The moment I pass that order that without due process you cannot, they will immediately exercise 18 and remove you.
Maybe then perhaps we may think of subsequent steps. As of now, if that falls from your lordship, perhaps my client would be, I think, happy.
Happy. Huh? The petitioner herein, which is a society registered under the Societies Registration Act 1860, have assailed the actions on the part of the respondent authority to in putting barricades in front of the flag station of the petitioner society over the land presently in possession of the petitioner, measuring 12 kathas under 2nd RS Dag number 2678 part of Moza Silchar town, Pargana Barakpur, in the district of Kachar. From the facts as seen from the writ petition, it appears that there was some sort of permission being given for which the petitioners herein have set up their flag station. Be that as it may, the land wherein the petitioners is in occupation is a government land, and as of now, the petitioner have not been issued any settlement, any allotment or settlement. Under such circumstances, in view of the settlement rules, the petitioner have no right over the land in question, but for the permission which was granted under Section 6, Rule 16 of the settlement rules to remain in occupation. This court have also taken note of the submission made by the learned counsel appearing on behalf of the petitioner, that as the petitioner have been allowed to remain in occupation of the land, and there has been no action, any other action taken, or any decision given, a decision to evict the petitioner, the petitioner's right to enjoy the land cannot be taken away, since the due process of law being followed. I've also heard Ms. Yudas, the learned senior government advocate who submits, additional senior government advocate who submits, that the land in question is a government land, and in view of the traffic congestion out in and around the Silchar city, the respondent authorities, in order for administrative convenience, have decided that such buses should not be allowed to ply. Per contra, Mr. So-and-so, the learned counsel appearing on behalf of the petitioner draws the attention of this court to paragraph number 5 of the affidavit filed by the respondent number 4, wherein it has been mentioned that the policy decision is only in respect to interstate inter-district, and long-distance buses. However, the petitioner association is a conglomerate of various members who runs minibuses in and around the city. This court, therefore, upon hearing the learned counsels of the parties, is of the opinion that if the petitioner has been granted the permission to be in occupation, which apparently seems to be in view of the documents on record, the responding authorities can only deprive the petitioner of such permission, deprive the petitioner of the rights over the land insofar as possession based upon permission by following the due process. Accordingly, this court therefore directs the respondent authorities to remove the barricades which was put by the respondent authorities through the local administration in front of the flag station of the petitioner society. Be that this court, however, for the purpose of clarification, observes that the instant direction so passed for removing of the barricades shall not deter or affect the rights of the respondent authorities to follow the due process for the purpose of eviction of the petitioner.
Supplemental is item number 42, fixed at 2 p.m.
Yes, Mr. Naik.
Yesterday, affidavit has been filed. And so far as my instruction is concerned, Lordship, yesterday team of GMDA Lordship went to the place, Lordship, and they have the necessary verification, and the necessary orders is going to be passed within a very short period of time.
Do something so that you have something. Because if you do something, then only people will fear. As per law, obviously. Do something if you have to do. And imposition of you always, as per the act, you can very well do something at the cost of the person who has violated it.
Lordship, the assistant engineer of GMDA already had gone to the site, Lordship, on 11/7/2018.
We are concerned with now. He says that they are doing something. We'll have it after vacation.
Lordship, GMD had filed affidavit yesterday. Your Lordship, I can to see paragraph 11 of the affidavit.
Affidavit
of GMD, my lord. Filed yesterday. Paragraph 11, my lord.
Paragraph
11.
Yes.
So, you cannot see the land in question was beyond the jurisdiction of the GMD, and that has been included in terms of notification dated 16/10.
Para
11, my lord.
11, that with regard to the statements in paragraph 22.
Yes, my lord. The writ petition reported begs to state that it is matter of record that the area presently falls under the jurisdiction of the GMDA and governed by the GMDA Act 1985, but land use has only been notified as per notification dated so dated 16/10/2020 for enforcement. So this area, my lord, my full submission was beyond GMDA, my lord, and this has been included newly in terms of notification dated 16/10/2020. Now, my lord, GMD is having an authority. Now they can exercise.
He is not on the question of land use. He is on the question that you have constructed without the permission. That is the question.
Now,
land use is on a different aspect.
Now, in the aspect of my lord, claim permission, your lordship can have a look, my lord.
Yes.
Permission for construction of Assam type godown was obtained by in the name of petitioner number 1, my lord, herein, in the year 2012 from the then Panchayat president.
So what?
Because at that time, Gaon Panchayat was having authority to grant NOC. And accordingly, this NOC was obtained. Not by the respondent, my lord, but by the petitioner number 1 and other co-portadar.
Lordship, it is a fully false document, Lordship. My mother and grandmother never applied before the concerned authority for getting the permission for warehouse construction, Lordship.
Anyway, then also, well, how do you take care of Section 25? Which mandates out there that you have to have the permission from the GMDA, because GMDA, the land falls within the ambit of the GMDA. This is being done in view of the GMC. GMC, that area may not be covered, but the GMDA is still covered.
My lord, this has been done, my lord, in terms of Assam Municipal Act 1956, my lord.
Understood. But then, therefore, GMC would not be there. But does it override the provision of Section 25? In view of the categorical provision out here that notwithstanding any other law, the GMDA would have the permission.
My lord, earlier, similar jurisdiction was vested upon the GMC and GMDA. Both the authorities were having power to grant NOC for construction, my lord. Now, my lord, this has been confined that GMD.
When there is conferment of both the jurisdiction in the same place, definitely. But here, where the GMC has nothing to do, then obviously the GMDA will, because there it makes it very clear. Who has filed the suit?
Present petitioners, my lord.
They have filed the suit.
They have filed it.
For?
Short for declaration of title, recovery of possession, my lord.
That is okay.
Lordship, the suit was filed in respect of the tag number 405, Lordship. But in respect of tag number 270 and 278, there is no suit is pending, Lordship. Title suit.
Yes.
But 405 has also been included in this petition, my lord.
Here the notice which is given at page 131 is of tag number 277 and 278.
One more notice is there, my lord, in respect of tag number 405 also.
405, let us not take into account. Let us go into 277 and 278. It is not there. So, Mr. Nayak, what are you doing?
So yesterday, I'm waiting for the report. Yesterday they went here. They did the verification. We're waiting for what?
Pursuant to the order passed by the court, the Secretary of the Guwahati Metropolitan Development Authority had filed an affidavit stating inter alia that no due notices were issued to the respondent number 4 for the purpose of submission of the NOC and the approved drawing. However, the respondent number 4 did not submit the NOC and the approved drawing, for which show cause notice was issued and no reply was submitted by the respondent number 4. It has also been mentioned that the GMDA authorities have also issued a demolition order dated demolition order under section 88. However, from a perusal of the said affidavit, it is not known as to what further steps were taken. Good stop. Today, Mr. P. Nayak, the learned counsel, appearing on behalf of the petitioner, GMDA authorities, submitted that yesterday, that is on, had the GMDA authorities had made an inspection and is supposed to submit a report. Full stop. On a pointed query made upon Mr. P. Nayak as the standing counsel as to whether the GMDA has the jurisdiction and authority over the area where the land is situated, the learned counsel submits that the area falls within the jurisdiction of the GMDA. Therefore, in view of the above, it is clear that the mandate of section 25, it's 25, no?
25.
25. 25 of the GMDA Act 1985 is required to be followed. And without there being any approval, therefore, any action, anything which has been done, the GMDA authority would have the powers to do so in terms with section 88 or 87 and 88 of the said act. This court fixes the matter again on 5th of January 2024 so that an update can be given by the GMDA authority council as to what further actions have been taken pursuant to the report to be submitted today.
Much better.
Number 46, fixture 2.
What is, anything happened?
One proposal has been sent to the government of India.
So you have given now.
Yes.
Now you are to decide. Who is appearing for the Ministry of?
Dear my lord, actually ministry is not made party to particular area, it may not be. And my humble submission before Lordship that is Deputy Solicitor General of India, Architect Statutory, any or central government, any council is directed to.
We'll take up after some time.
To communicate this letter.
Ask Mr. Architect Chaudhary to be present.
Yes.
We'll take this matter after some time. Huh?
Architect Statutory. Because it will be at least to
Because
communicate.
this needs to be forthwith done because
Yes,
otherwise it will have. And
Lord,
I have Mr. Gogoi.
or any central government council also can.
No.
Yes.
Any central government council would not have.
Anyhow, I'll come.
Only thing is you have put one person.
Even
Who did-
earlier also it was 1%.
Huh?
No. Earlier it was not. Earlier 3%. For
Because I'm telling you,
Lower
this
Assam,
is not one
Upper Assam,
matter. It will be a huge. It will be.
yes.
It will be huge.
Huge,
He
my lord.
would not be in a
And
position.
that too, they have to come from entire from that will be from
Today,
Assam.
Lordship will make one observation. And for the next 1 or 2, that's what
I think you have to do something because one person would not. And number two is how do you take care of a retired person?
Yes.
Because retired, the reason why they appoint them is for that no payment is required because it falls within the ambit of the duty to arbitrate.
Sure.
That is the reason why NHAI or the central government appoints. Now, the moment he's a retired person, somebody has to pay him. Who is going to pay? This has a serious connotation.
Yes.
But anyways, ask him, because this again has to be taken after the vacation, but I will ask them, let him come. But you have to tell them, because isn't that the idea behind?
Yes, yes, my lord.
You have, I have
Yes,
seen it in
because
some
that is
other
why-
matter.
That is why it is an appointed under provision of section TA or under provision of National Health Act 1956. Though it is a provision of Arbitration Conciliation Act, but it is appointed under provision of this. That is why
No, although
No, no,
as per the act, you can appoint anybody.
anybody
But your policy,
payment.
no, your policy is different.
Yes.
Your policy, as I could see in some other matter you have shown,
Hmm.
that you don't have you want somebody because they will be under the compulsion to act without any further payment. That is the reason why.
Yes.
We'll have the clarification of it.
But another big thing appears another, I'm telling you another thing. Recently, the Supreme Court said that an arbitrator is required to pay reverse tax, GST. Now, this has a lot of implications in these matters also. If he has to pay reverse tax, meaning that he has to collect it from them, then how will he pay here? These are very important things which are there. Earlier it was okay. Arbitrator did not pay anything. Now he has to pay reverse GST. Now if he has to pay reverse GST, he has to ask from them. Now would they now be liable to pay? Because the Act otherwise says it will be just an arbitrator. So something has to be done in order to resolve this issue. It is made very complicated. What is done outside, Mr. Borua?
Outside.
Outside Assam?
I'm not worried about that point.
We will ask him to be. We'll pass orders today, but you need to inquire that.
Lordship, if your lordship, these complications are coming up. Suppose this he is Mr. Burman is been appointed that person. Immediately he will take over the matter. That is why before as lordship, this complexity is coming. Let them take the instruction on this particular point, my lord. Because as this matter is before lordship. Suppose he's been appointed. Tomorrow letter has come. Immediately he will start job. Then again may come complicated. That is a this query.
No, that is not for me, but I'm asking him.
That is actual.
Because I will only make an observation that taking into account the various litigation, would it suffice? So the government will also have to take a note of.
That part may be indicated.
Yeah, that I will indicate. But ask me that, because that is a very important issue. None appears on behalf of the petitioner on call. It is further seen that the petitioner has not appeared since 2019 on various dates. It seems that the petitioner is no longer interested in the matter for which the instant petition stands dismissed for non-prosecution. Interim orders, if any, stands vacated.
9.
So in view of the Northeast Industrial Policy, my lord, 7, central government has issued the scheme, my lord, Central Capital Investment Subsidy Scheme.
Central
Capital Investment Subsidy Scheme 2007. Under this, my lord, the petitioner established an industry costing about, my lord, 83 crore and all. Thereafter, my lord, as per scheme, he has submitted the, my lord, subsidy claim, and General Manager, my lord, District Justice Center, he has reduced the sum to some extent that your lawsuit find, my lord, past your lawsuit may just see, my lord, page 29.
Yes, government, why haven't you filed affidavit?
Since 2015, my lord, last time also 2021, my lord, order was passed allowing them to file activity.
Yes. You are for?
Industries, Lordship.
Why you are not filed the affidavit?
Lordship, my senior is coming, Lordship.
So senior is going to say that not filing affidavit in spite of time being taken in the year 2022?
No, Lordship, he have got something instruction. I have not got any instruction.
So none appears for the
No, Lordship,
industrial
he is coming,
department on call then.
I called him, Lordship, he is coming.
Now, my lord, if
List the matter again on. We finish it up on 11th of January 2024. The record reveals that on various occasions, the Industries and Commerce Department have sought for time for filing the affidavit, but till date, the affidavit has not been filed. Under such circumstances, this court makes it clear that if the Industries and Commerce Department does not file the affidavit on or before 8th of January 2024, this court shall dispose of the instant writ petition on the basis of the materials available on record. It is relevant to take note of that since 2015, the instant writ petition has been pending.
Lordship, as far as Industries Department is concerned,
You don't want to file?
I mean, I don't have much role in this. It's a role will be played by the central government because the policy central government, operational guidelines of central government, they're challenging that. So basically, and this is a case of high value claim. So this goes to the empowered committee. Empowered committee will be considered by the Under Secretary Government of India.
Industries and Commerce Department and Union of India.
That will be point.
Both of you either file the affidavit by then or else it will be taken on the basis of Industries and Commerce Department or State of Assam and the Union.
Then
yes.
We have filed affidavit, Mala. Paragraph 4, Mala, we have stated that this is Mala, and this Mala BGR lab.
Oh, yes. You've got the instructions?
Mala, I filed the affidavit, Mala.
Oh, fantastic.
Paragraph 4,
What right do you have? No right.
I don't.
Got in train.
Yes,
You have no right. Dismiss it. The instant writ petition has been filed challenging the notice issued under the Regulation 18.2 of the Assam Land and Revenue Regulation 1886 by the Circle Officer Sonai Revenue Circle, Sonai Kachar, asking the petitioners to vacate the VGR land measuring 34 bighas under DAG number 478/465 within Moza, Rajghat, Pargana, Devi. What is this? Pargana is what?
David Sonabad.
David
Sonabad.
under Sonai Revenue Circle in the district of Kachar. The case of the petitioner is that the petitioners have been residing. The petitioners as well as the predecessor in interest have been residing for the last 45 years in the said land, and as such are landless people for which the petitioner should not be evicted in terms with the said notice. This court have also perused the affidavit in opposition filed on 4/12/2023, wherein also it has been mentioned that the lands in question are VGR lands. Is it or not?
Yes.
And as such, in order to free the VGR lands, the said notice was issued. The said action on the part of the respondent authorities is in accordance with the provisions of Rule 18.2 of the settlement rules under the Assam Land and Revenue Regulations 1886, and further is also in consonance with the judgment of the Supreme Court in the case of Jagpal Singh versus State of Punjab, reported in so and so. Under such circumstances, this court finds no ground to interfere with the order, with the notice which have been issued to the petitioner. Full stop. The respondent authorities, therefore, shall be at liberty to take such action as deemed fit in accordance with law. Before parting with the record, this court, however, observes that the petitioners herein would be at liberty to file appropriate application in terms with the land policy of 2019 if they fall within the categories of eligibility if they are eligible in terms with the said land policy. Full stop. This observation, however, shall not affect the rights of the respondent authorities to take such action in terms with the impugned notice.
Six, as per 6 malat land policy of 19 malat PTR is not malat land.
No. In some other land. I have asked you, you remove them, throw them out. Only thing is, they will be at liberty to file application for
if
as
any
per the
other
land policy.
malat interim order.
Oh, the interim orders so passed earlier stands vacated.
Apply.
Yes, Mr. Arbitrator Chaudhary. You see, what has happened is a big issue. You see, all these land acquisition matters, more particularly done under the National Highways Act. If there is a question of inadequacy of compensation, a person, either of the party, even the, unlike land acquisition proceedings where the requiring authority cannot challenge, here either of the party can challenge and file an application before the competent authority, and the competent authority will forward it to the central government, who shall appoint an arbitrator. Now, what was happening all this while? The Ministry of Rural, Ministry of Transport and all, they were appointing the divisional office commissioner. And their basic policy as the arbitrator, their basic policy is that, look here, if these people are there, the divisional commissioner, they are already getting the salary from the government, so there will be no additional expenses. That was the basic policy. Although that is not the mandate of the Act. They can appoint any arbitrator because it says the arbitration shall be in terms with the Arbitration and Conciliation Act. So they can appoint. Now what has happened in the meantime, the government of Assam removed the divisional commissionerate and brought in the district commissioner Speckout. Now with this, the notification by which these divisional commissioners were appointed, the arbitrator is gone. There's no post. So there has been a lot of matters. Now, when these lot of matters are being referred out there, nothing is happening on the ground that there is no arbitration proceedings. There is no arbitrator. Now, what has happened? The government, the NHAI says, that look here, we have been talking with the government. The government, the GAD department says that we have referred it to the Revenue Authority. Now the Revenue Authority says that one some Ashok Kumar Burman, IAS retired, he has been said that he can be nominated as an arbitrator. Now this matter has gone to the Ministry of Shipping and all, for which you come in. Now you see the main problem which I am saying. There are many litigations which are being filed on daily basis before this court challenging the quantum. For the purpose of inadequacy, there is no problem. For the purpose of apportionment or entitlement, there is no problem because then it will be covered under 3H, 4, 5, and then 7, the district judge can do. As regards the rights, who should get it. But as regards inadequacy, it is only the the arbitrator who can do. Now, one problem is you are now to notify in view of that. They have given the name. So something needs to be done on that basis. The second is, the most important thing is, this person now is retired.
So what they were thinking is not going to happen.
So that is not going to happen. Now, in the meantime, if you don't appoint also somebody, there will be a floodgates of litigation in all the courts out here. Because somebody has to decide. Or there will be, and further to that, this court, earlier there were 3 divisional commissioners who were looking into it. Now they have appointed one that to a retired person. Would he be in a position or capability to decide that, which is a huge?
Yes.
You go for Karbi Anglong, you go for any other place, there is everywhere there are litigations on inadequacy.
Yes.
So how can the one person decide everything? So that is again going to be a huge problem. So therefore, as this matter has been given, so therefore I am requesting you to take it up with the ministry as regards this and report and inform this court on the next occasion. What is this thing? Okay.
Yes, yes.
I think
I will.
because you are not a party, they have not made you are a party, but
Yes,
then also NHAI is there, so I am doing it.
I will do that.
He's holding the official secretary,
Huh?
although he is a retired person, but he is holding the post of official secretary.
He's the area of special secretary.
Retired person, are that? Retirement supply.
अरे पार्टी को पड़े क्योंकि payment
Special secretary, that means the government is going to pay.
Already having
He will be advised on an extension. Earlier, the office was made. Now the problem which will arise is this. They have not made the office. Now if there is a change, if he becomes old or whatever may be, the entire thing you have to move under then, because you see 3G6. It says that all the provisions of Arbitration and Conciliation Act 1996 will apply. So if something happens to him or he is incapacitated, then the entire thing goes to, you have to then move applications under section 15, which will again be another huge problem. Then we have section 29, which mandates that you have to complete the year within 1 year, and maximum extension can be for 6 months. Now, how is it possible for one single man to take up so much of arbitration?
Not possible.
It will be next to impossible. This is not something which is very feasible. Earlier it is okay, they used to delay all these things.
Not to make another query from me. I have asked them, it has come to me for regarding Tripura. Tripura, what they are doing, there is a notification on 20th November of 2020. Arbitrator is appointed here district-wise. And that particular district magistrate and collector of that particular district.
That is again wrong.
But again wrong, because that is I'm also putting on that, because whenever matter is go to DC, it will go. The deputy commissioner. But again, this is also
that is absolutely wrong. Because that can't be so, because I don't know about Tripura, but in Assam, the DC means the ADC.
Yeah.
And here the ADC is the competent
authority.
Then how do you take care of that?
That their matter maybe. Yes.
Okay.
Yeah.
Pursuant to the order passed by this court on 18/12/2023, Mr. S. Tutto, the learned standing counsel of the Revenue Department, has informed this court that the Deputy Secretary to the Government of Assam, Revenue and Disaster Management Department, have written a communication to the Ministry, to the Undersecretary, Ministry of Road, Transport and Highways, seeking nomination of Sri Ashok Kumar Brahman, IAS, bracket retired, Special Secretary to the Government of Assam Revenue and Disaster Management Department for appointment as the arbitrator of the state of Assam for settling the disputes in connection with acquisition cases acquired under the National Highways Act 1956. The Learned Counsel therefore submits that the tenor of the said letter is to the effect the arbitrator is to be appointed only as regard the tenor of the said letter in effect is for appointment of an arbitrator to decide in terms with section 3G5 and not in respect to such other proceedings as wherein the principal civil court has the jurisdiction in terms with section 3H. This court had requested Mr. Arbitrator Chaudhary, the learned DYSCGI, to intimate this court, to apprise this court on the next returnable date as to what further steps have been taken by the Ministry of Road Transport and Highways for the purpose of appointment of an arbitrator. The registry shall show the name of Mr. R.K. Dev Chaudhary, the learned DYSCGI, in the cause list henceforth in the instant proceedings. List the matter again on how much time? 22nd January? On 22nd of January 2024 for further instructions in the matter. Before parting, this court, however, finds it relevant to observe that any delay in appointment of an arbitrator by the central government in terms with the National Highways Act 1956 would delay in adjudication of references to be made to the arbitration in terms with Section 3G, which not only affects the rights of the persons, of the parties who seeks for the reference, but if there is a delay, it may also lead to further enhancement and accumulation of interest. This court expects and observes and expects that the ministry, that the concerned authorities in the Ministry of Road, Transport and Highways shall take urgent and expeditious steps so that the arbitrator is appointed at the earliest. Next. This court also finds it relevant to observe that there are various land acquisition proceedings, and on daily basis there are various writ petitions have been filed before this court challenging the inadequacy of compensation. Seeing the amount of litigation, the government, both the central as well as the state government, shall also take a decision as to whether so much of the litigation can be decided by a single arbitrator, taking into account that such arbitration has to be in terms with the provisions of the Arbitration and Conciliation Act 1996 and Section 29A. Na?
Yes.
29A mandates a period of completion of the such arbitration proceedings, and failure to do so would render the said proceeding, failure to do so would render the mandate of the arbitrator, would terminate the mandate of the arbitrator. A copy of the registry shall give a copy of the, you take, no, I will download your topic.
11.
What is this matter? None appears on behalf of the petitioner on call. It further appears that the instant writ petition has been filed challenging the expression of interest and challenging the notice inviting tender dated 5/7/2018. Full stop. There was also no stay so granted by this court. Mr. B. Gogoi, you are there?
Yes, madam.
Appearing on behalf of the
Initial.
respondent submits that the said petition has in the meantime become infructuous. Taking into account the above, the instant petition stands dismissed as it has become infructuous. None appears on behalf of the petitioner on call. Further to that, the petitioners have also not filed the additional affidavit as directed by this court on 16/10/2023. Under such circumstances, this court is not inclined to extend the interim order which was passed on. (8/10/2018). It is further made clear that if the petitioner is not represented, it is neither represented nor files the affidavit nor files the additional affidavit on or before the next day, the incident with petition shall be dismissed for non-prosecution. List the matter again on 19th of January.
May it please your lordship. Lordship, I am appearing for respondent number 227. Lordship, the petitioner is informed us, my lord, he could not appear today. He is on Itanagar.
He has challenged my award.
Lordship. Lordship.
The instant petition has been filed challenging the award in reference case number 1/2018. So far, it relates to payment of bonus and payment of overtime to the respondent numbers 2 to 7. This court admits the instant with petition and calls for the records of the said reference case number 1/2018. So the registry shall take appropriate action steps for requisitioning of such records. List the matter for hearing in the month of March 2020. Petitions for hearing in the month of March 2024.
Okay.
directed the pollution control board to take effective by
Where is the pollution? This court, by an order dated 29/11/2023, had directed the Pollution Control Board to apprise this court as to what steps have been taken pursuant to the application filed by the petitioners seeking consent. However, today, when the matter is called, the Standing Counsel for the Pollution Control Board is not present. Under such circumstances, this court adjourns the matter to be listed again on 5th of February 2024. It is made clear that if the Pollution Control Board does not if the instruction sought for in the order dated 29/11/2023 is not placed before this court by the Pollution Control Board, the member secretary of the Pollution Control Board shall be personally present in the court at 10:15 a.m. Yes. What is this?
Lord, non-payment of compensation, my lord, for constructing a dike in the, my lord, Muricam, Yemen.
Now what happened? You have filed your reply.
My lord, it 1 week time may be granted, madam. I'll reply, madam.
What?
1 week time may be granted. I'll reply.
I gave you on 27/9.
Okay, that's not maybe.
If I remember correctly, Mr. Goswami, this is a land where you are saying that you are not acquiring, not necessary for you to acquire. Isn't that
right? So if he wants to dispute it, my lord, can file a reply, then lordship will hear him.
This court, by an order dated 27/9/2023, granted the liberty to the petitioner to file reply to by 7/11/2023. However, the petitioner have not filed a reply and had sought for yet another accommodation. List the matter again on 23rd of February 2024. So it is made clear that if the affidavit in reply is not filed in the meantime, the instant this court shall take up the matter on the basis of the materials available on record.
The petitioner has settled the matter with the respondent bank, and the respondent bank has defaced the account and are allowed to take the salary.
Huh?
If the petitioner has settled the matter with the respondent bank, and the bank has defaced the account.
Why?
Because some loan was pending, if the petitioner has repaid the loan,
Then
the account was defaced, and he was withdrawn to the salary.
who is paying for the respondent? Respondent which bank?
PNB Bank.
Huh?
Punjab National Bank.
They have filed an affidavit in opposition.
Yes, yes.
What do they say?
They say we are defaulter in payment of outstanding dues.
Outstanding dues?
Outstanding loan.
Huh? So they have freezed your account.
Now they have defreezed because
They have defreezed.
because I paid the loan.
So you have nothing. Infructuous. The learned counsel appearing on behalf of the petitioner submits that in view of the fact that the account of the petitioner have already been defreezed by the respondent bank, nothing further remains in the instant writ petition. Accordingly, the writ petition therefore stands closed as it has become infructuous.
So far as item 18 is concerned, I got some instruction that that person already expired and he got his matter has been settled. So it is verbal instruction. It may be fixed after vacation. I will take full instruction.
Huh?
That petitioner is got the relief.
Who?
Petitioner.
Which petition?
This item 18.
He has got the relief.
Informed that he got the relief, but that man already expired 3 months ago. That I confirm. So
He has got the relief.
Madam will fix for clear instruction. He is in the expired. So ultimately it will be.
Yes, Mr. Sharma, what is the matter about?
Matter is about that he's asking, there's a bill that's been pending and we have disputed the bill. We have said that we do not owe you any bill, and that's why we have also given a file affidavit in detail affidavit regarding that. In fact, is the dues that we get from you, and that is the entire matter about it. He's asking for, because he was operating as a CBDT with the CBDT lines which he has to connect as an outsourced employee, and outsourced franchise.
Okay, we'll have it after vacation.
After vacation,
All the matters after vacation, taking into account the submission of Mr. J. Ahmed, that the petitioner in WPC number 5446 of the 2021 had expired and he would like to take appropriate steps.
So far as item 19 is concerned, my lord, in that case, affidavit not filed.
Oh, that's already ready. It's a connected matter.
Item number 19, Mr. S.P. Sharma submits that he would file the affidavit within 2 weeks. List the matter again on 29th of January.
Much well.
20.
The matter is pertaining to promotion to the post of civil chaser.
Huh? Promotion?
Promotion.
What am I doing with promotion nowadays?
This has been allotted to this court. I think. Have you filed affidavit? I have filed my affidavit in reply.
We also filed a reply, my lord. But the affidavit filed by my High Court has not been filed up.
I will make a copy.
So the pleadings are complete? You have filed reply?
Yes, ma'am.
The pleadings being complete, list the matter for further consideration on 6th of February 2024.
CN 44.
Oh.
My lord, one affidavit has been filed today, my lord. For the opponent side, my lord. I want to file
Then they have filed the affidavit.
Yes, my lord. Today, my lord.
Oh, that one.
Yes, my lord. Copy, my lord.
You've got a copy.
Yes, my lord.
You want to file reply?
Yes, my lord.
That is pertaining to that block development thing.
Yes, my lord.
Okay.
My lord, one thing, my lord, they have submitted.
You file your reply because here he says that you were not entitled to any amount.
Yes,
There you did not make any supplies.
Now, my lord, my proposal is that, my lord, let them file the detailed affidavit, my lord, regarding my supply order which I have submitted, my lord.
This is not for this court to do all these things. You file your reply, then only I will consider that. Here he says that you have not made the supplies. Why should I? Without an objection to this.
No, my lord, they have not stated anything about my supply bill which I have annexed, my lord. And in pursuance of the supply bill, my lord, it was updated.
No, yesterday I saw that affidavit where Mr. Devnath was produced it day before yesterday. Isn't that the case? This is regarding the supplies. You say that you have made the supplies, you have nothing to do with the implementation.
Yes,
That I remember that.
Yes.
So he showed me that affidavit he has filed.
Yes, my lord.
So there the block development officer says that, oh, look, yeah, he did not make any supplies. That is what I could see. Anyway, the learned counsel appearing on behalf of the petitioner submits that the an affidavit has been filed by the respondent by the block development officer as directed by this court on (9/10/2023). He submits that he would, however, the said affidavit is not on record. Lists the matter on 19th of January 2024. In the meantime, the petitioner herein would be at liberty to file his reply.
Obliged.
Protest item 22.
May please, your lordship. In this matter, the petitioner has to take steps on respondent number 6 matter.
Respondent number 6, who is appearing? None appears on behalf of the petitioner on call. Further to that, the order of the Lozima Court dated 19/5/2022 shows that the petitioner had not taken steps against the respondent number 6. Taking into account the above, this court fixes the matter again on 22nd of January 2024. It is made clear that if the petitioner does not take steps against the respondent number 6 on or before the next date, the instant writ petition shall be dismissed insofar as the respondent number 6 is concerned.
20.
Like the official in 1923 regarding service on 6 and 7. Now it may come up for admission. Complete.
Service complete. Service being complete lists the matter for admission in the on 19th of February 2024. He takes fresh steps. His last time took steps upon 21/8/2019.
Lordship, we will be allowed to impede the new chief engineer because since the pendency of this case, the chief engineer has retired. So we will be allowed to impede the current new chief engineer of PhD.
Then you have to take appropriate steps by issuing notice to him.
Yes.
The learned counsel appearing on behalf of the petitioner submits that during the pendency of the instant contempt proceedings, the respondent chief engineer had already retired and the new incumbent, and he would like to take appropriate steps against the new incumbent. List the matter of 6 weeks. In the meantime, the petitioner shall be at liberty to take effective steps. What was the direction passed? For payment within?
For consideration of my representation within a period of 3 months regarding outstanding.
And you can't give a notice to him, nah?
No, Your Lordship, it was specifically to the chief engineer PhD department.
Within what time?
Within a period of 3 months, Your Lordship.
Because you have to give notice against to him, nah?
Yes, Lord.
Then wouldn't you have to do after 3 months? Now you should know. You can't make him a party unless you inform him. This is a contempt proceed. So the person has to know that, look here, this is an order by which you are to comply. List the matter of 3 months.
25.
You are supposed to file a reply.
Okay, we have already submitted the handbook and the cancel check to the authority as well as the
Yes, sir, you have to take up instruction, Lordship.
Oh,
On the last occasion, Lordship, petitioner is directed to file the vendor retest, Lordship. He has not-
25, na?
Since 2019, he has not submitted the vendor retest, Lordship. But
Huh? NJ Gogoi so and so Ms. M. Bormon admitted that the executive engineer by letter requested is to submit the documents including cancelled check so and so for resubmission of the demand proposal amount. Has submitted that did not receive the state letter and date. Then when did you submit?
On the month of July. Lord. After the order dated
order dated
2/6/2023.
Okay, Mr. NJ Gogoi, the learned counsel appearing on behalf of the petitioner submits that in pursuance to the order dated 2/6/2023, the petitioner had duly submitted the documents so mentioned in the order in the said order or in the month of July. He, however, submits that till date no action has been taken. On the other hand, Ms. M. Borman appearing on behalf of the executive engineer PWD, Gulaghat Kumtai submits that to her instruction such documents have not been submitted.
no, Lord, I have no instruction whether he has submitted.
No.
I have to take instruction, Lordship.
Miss
Latest after
Miss
the-
M. Borman, Miss Borman, the learned counsel appearing on behalf of the executive engineer PWD Gulaghat and Kumtai submits that she has no instructions in the matter. So taking into account the above, list the matter again on 19th of January 2024, on which date Ms. Borman shall apprise this court as to what further steps have been taken pursuant to submission of the documents by the petitioner. None appears on behalf of the petitioner on call. List the matter after
Respondent 2.
appears on behalf of the petitioner on call. List the matter after the vacations.
As per Kazima court order, matter, I have taken steps on 28. That's not for 7.
Taking into account that the petitioner have duly taken steps, list the matter, taken steps upon the respondent number 7 and 8. The list the matter again after completion of service upon the respondent number 7 and 8. Yes, no steps taken.
Only one time. After tomorrow we'll take the paper.
How can you take the day after tomorrow?
No, tomorrow you'll
Take that. No. What is the order passed? Let us see. You don't understand what the steps, you don't know. You have to issue new notice to that person, new incumbent. The learned counsel appearing on behalf of the petitioner submits that he may be granted another 2 months' time for the purpose of taking steps upon the new incumbents. List the matter in the month of April 2024.
Order complied with, my lord. The amount has been released on 27/11/2020.
None appears on behalf of the petitioner on the call. On the other hand, Mr. D. Gogoi, the learned counsel appearing on behalf of the respondent submit that the order dated 18/11/2019 passed in WPC number 5477/2019 have been duly complied with on
27/11/2020.
27/11/2020.
My lord.
And as such, nothing further survives. Taking into account the above submission, the instant contempt proceeding stands dropped. Yes.
Lordship, in this case, order is not fully complied, but payment for 13,31 was directed by the Honorable Court. So full payment has not paid.
Huh?
Full payment has not paid.
What was the direction? Dispose of the petition by allowing the prayer made by the petitioner. Consequently, they are directed to refund the deducted amount from the bill so that within a period of 3 months from the date of receipt of a certified copy of the order. It is also made clear that in the event if it is found that it had already been deposited with the foreign, the concerned authority shall take measures to retrieve the amount from for the purpose of making the refund. Yes.
Well, the sealing proposal was sent in the month of September 22, and some amount has already been made to the petitioner as per my instruction.
Entire amount?
The entire amount, I tried to contact him, just I could not, because the proposals on all these things are of September 22. By this time, this sealing proposal is of September 22. By this time, possibly it ought to have been done. Some amount has already been received by him also.
Some amount would not do.
That
3 months the payment was to be deposited.
It has been proposal.
There's no quantification, there's no verification. Only thing is that you cannot collect that amount. That's all. You have to give it back to him.
The refund of the forest work.
I know.
But in fact, the sealing proposal was sent for 13,31,000 rupees. So
How much have you paid?
13,31,000.
You have got it.
No, Lord.
How much you have got?
He got 12,38,115.
And then there might be some more deduction. Provide the calculation on what basis. Okay, we'll have it on the 8th of January. Get your instruction. Mr. Dinath, the learned counsel submits. The learned counsel appearing on behalf of the respondent submits.
I am appearing for 2, respondent number 2.
2 submits that the sealing proposal for the amount of rupees 13 lakhs
31,306
306 was duly submitted, and out of that an amount of rupees 12 lakhs 38,000
115
115 have been said to be received by the learned counsel for the petitioner. Mr. Dinath shall place before this court on the next date as to whether the order passed by this court dated
4/9/2019.
4/9/2019 in WPC number 4625/2017 have been complied with, and if not, when the remaining amount would be paid. List the matter on
8.
Oh.
8.
As per order.
None appears on behalf of the petitioner on call. Further to that, the petitioner have not taken steps for substitution of the respondent number 1 in deference to the order dated 12/2/2021. It also appears that on 16/7/2021 the petitioner did not appear, and today also the petitioner is not represented. It seems that the petitioner is no longer interested in the instant proceedings, for which the contempt proceeding stands dropped. The petitioner is not represented. it is also seen that on 26/6/2023 also the petitioner was not represented. Further to that, the petitioner have also further to that, the steps have also not been taken. Further to that, the service of notice upon the petitioner, sole respondent, have not been effected, and it has been reserved back. Under such circumstances, what is that order? These are problems, they file it here. Under such circumstances, it seems that the petitioner is no longer interested in the instant proceedings, for which the instant contempt proceedings therefore stands dropped. Yes, complied.
But my communication says that the party has informed the authorities that he will withdraw the petition. But here the order is an interim
You're
order.
withdrawing. Are you withdrawing?
Lordship, of course, it's a contempt petition between the court and the contemptor. But my instruction is that the petitioner is no longer interested.
Order is that in the meantime, it is directed that no award shall be given pursuant to the newly floated tender without leave of the court.
Without leave of the
And the order was of 19/6/2020. Possibly something has happened in the meantime.
The learned counsel appearing on behalf of the petitioner submits that the instant contempt application was filed alleging willful disobedience to the order dated 19/6/2020, whereby passed in WPC number 2550/2020, wherein there was a direction that no award shall be given pursuant to the newly floated tender without the leave of the court. The petitioner thereupon, it has also been submitted that the petitioner thereupon have lost interest in the said tender proceedings, and as such would not therefore like to pursue the instant contempt proceedings. So accordingly, the instant contempt proceedings stands dropped against the contemptor, against the respondent. Contempt proceeding accordingly stands closed.
Report.
Yes, you have filed affidavit.
Yes, Lordship. I have mentioned in error number 7, Lordship.
Have you complied?
Petitioner has not submitted the proper bills, Lordship. Though he has not submitted the proper bills to the authority, the office has already submitted proposal for releasing of fund under GIA for payment of the outstanding bills, Lordship. So they have to submit the bills. On November 20 and December 20.
You want to file a reply?
Yes.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that taking into account the stance so taken in the affidavit in opposition by the sole contender, by the sole respondent, he would like to file a reply to list the matter on 19th of February 2024. In the meantime, the reply be filed.
36.
The IA was filed by me, my lord.
What?
For seeking leave to file rejoinder to the affidavit in reply filed by them. Otherwise, the case is pleadings is complete, my lord. It can be taken up for hearing after.
For hearing, my lord.
You want to leave?
Seeking leave to file a rejoinder, my lord.
Are these assertions new assertions?
Smile.
Huh? Or are they the same thing you want to against?
Some clarification, because on factual part, there's some clarification. Not new assertion, it was there in a written statement.
Huh?
It was there in the written statement which was filed before the learned court below. So that is not
What
a
is
new
this matter about?
It's an order passed by the Board of Revenue.
My lord. Understand. The Board of Revenue, instead of issuing a notice on the application file under Section 5, my lord. So the board has already admitted the appeal concerning the delay, my lord, without giving any notice to us.
Does Section 5 Limitation Act apply?
My lord.
How do you say so?
So that the appeal is to be filed within the period of limitation, my lord.
That is a different thing. But whether Section 5 applies?
That is especially not.
No, because it is not a tribunal, it is not a court. So Section 5 doesn't apply then?
No, they have to file
Because the Assam Board of Revenue, as I could see, they they pass the orders always that appeal is admitted pending keeping the maintainability of the
appeal, my lord.
delay open. Because they do so in view of the Banda Gowala judgment of 1971, wherein the full bench of this court had held that it is not a court.
Yes.
And as such, the Limitation Act does not apply.
Immediately by they have to file an application under Section 5, my lord. That application without issuing any notice, my lord, to the respondent, my lord. The board has already so much of bad respondent the delay, my lord, and admitted the appeal.
So, you are for the respondent.
I am for the respondent, my lord.
So, what can be done at
Only
best?
by
The only thing is, you see, the matter has been pending out here from 2018. It is not helping your cause or that cause. The only thing is that I can at best set aside that order and direct the board to consider your objection before condoning the delay. That's all. That is the only thing. Why do you need so many objections?
But the board has the power, my lord. If my lord may kindly peruse the Assam Board of Revenue Regulations Rule 3, it says that provided that an appeal or application may with the permission of the chairman be accepted if the chairman is of the opinion that compliance with any one or the more of the above requirements may be waived in the circumstances of the case. So the limitation is also there. So the board has the power.
But anyways, the question has to be decided on the merits.
It can be decided.
That to be decided by the board, my lord.
Let it be decided. What is wrong?
But only my and we will be given an opportunity to make submission, my lord, on the point of limitation, my lord. That is my prayer before the Lord, my lord.
Let us see that order.
Page 85.
Page 85, man. And it's 8.
Why should we keep it for another date?
Right.
Because these are questions of fact. Why should this court decide this? Let it go. Let it be decided on merit. Because the chairman otherwise have the power.
No, that power is there.
And not only that, you know section 151. Huh? The supervisory power has no limitation. Earlier when there used to be gross delay, the chairman or there was one member, Mr. D. Saikia, he used to tell us, put also 151. Because 151, this court has very well, on various occasions, have decided there's no limitation.
Ample power there.
So we don't interfere with disorder. Let the court decide. Because I think that will be in your interest as an early thing. Because the status quo is otherwise there.
Yes. Is that the proceeding has been solved?
Proceedings have been stalled here.
Yeah,
No?
in the
No,
board.
not the status quo order.
The board.
The order has not been stayed. I've heard the learned counsel for the instant appeal, instant petition has been filed challenging the order dated 10/7/2018, passed in case number 929 RA bracket DIB bracket close oblique 18 by the chairman of the Assam Board of Revenue. The only point on which the instant petition has been filed is that the respondent, the Assam Board of Revenue, the chairman of the Assam Board of Revenue have admitted the appeal and condoned the delay, have condoned the delay without issuing notice to the petitioner who were the respondents in the said appeal. Upon hearing the learned counsels for the parties, this court is of the opinion that the matter which is pending before the board has to be decided on merits. Further to that, this court also takes note of section 151 of the section 151 of the Assam Land and Revenue Regulations 1886, which empowers the board to pass to call for the records in respect to any proceedings and exercise the revisional jurisdiction. It is also right that this power under section 151 of the regulation can be exercised at any point of time. Taking into account the above, this court is not inclined to interfere with the order dated 10/7/2018. Be that as it may, this court directs the Assam Board of Revenue to decide the said appeal at the earliest and preferably within a period of 6 months. 6 months. From the date of appearance of the parties.
Only pay for the giving a liberty to raise their objection about the point of limitation.
Where is that order again?
Page 85, my lord.
The delay has been condoned. Then I have to set aside this order.
No, only my if liberty is given to my to argue to make submission on the point of limitation, my lord, that I think you will also can even observation, my lord. Allowing the respondent to raise objection as to the point of limitation, my lord.
No, if the delay, if I am not touching this order, how can I ask for, and the delay having been condoned, then I will have to interfere that the order couldn't have been confirmed. How is it possible? Both cannot go together.
Because whole purpose, my lord, actually I am challenging only because of that, my lord.
Your only ground is delay.
Delay, my
There is
lord.
nothing else.
No, on merit,
So argue on merits
my-
within a period of 6 months from the date of appearance of the parties. Taking into account that parties are duly represented, this court directs the parties to appear before the board on 22nd of January.
No, that my only my lord, liberty can be granted to me, my lord, to the respondent, to the petitioner respondent, my lord, to raise objection as to the point of limitation, my lord. That also allowed to my even liberty, my lord.
But when the delay has been condoned,
Even
no, once it is condoned,
Condoned.
how can I be? Be that as it may, the petitioner herein, who is the respondent in the said proceeding, would be at liberty to raise objection that the delay in filing the appeal have resulted in creation of rights in favor of the petition.
I would like to, lord.
I dispose that. Nothing remains. I have infructuous in view of the disposal of.
Petition IA for continuation of delay in preparing substitution petition is a repeat.
What?
Not continuation of delay in preparing substitution petition. Hello, the petitioner number 1 has expired. Now, her legal hair was to be
Who died?
well, I 1380.
Huh?
1380.
Who died?
Well, petitioner number 1 is the lordship now leaving behind sister-in-law and
Petitioner number 1 of which petition?
well, petition 8469
He died.
died.
Petition number 1.
Right.
Okay. So,
Our legal hair lordship are substituted.
how many petitioners is there?
Only one petition. Out of
Then why are you saying petition number 1?
no, lordship petitioner, two petitioners.
That is what I'm saying. Petition number 1 has died. And who is petition number 2?
Who is lordship another person lordship with same grievances lordship.
Huh?
With common grievances lordship is two petitioner.
For compensation of the allotted land acquired by the demand. Your lands were allotted to you.
Allotted, but land
Settlement not given it.
No, land has been
That
acquired.
is subsequently. I'm aware land was allotted and acquired on settled or not.
No,
Only allotted.
Right.
Then they took over. No settlement order passed.
No settlement order passed, Lordship.
So what right you have over the land? You may have right over the Jirat.
My lord.
But
That amount has also not been taken.
Huh?
That amount has also not been taken.
I can't, huh? The instant applications, what are the two applications?
My lord, one is for substitution.
And the other is?
For condonation of
The instant applications, the IA Civil 1380/2023 and IA Civil 1381/2023. Both the applications have been filed for the purpose of substitution, for the purpose of condonation of delay, as well as for substitution of the legal representatives of the petitioner number 1, who expired on
17/5/2020.
17/5/2020. This court have duly perused the contents of the said applications. And taking into account that the right survives upon the legal representatives of the petitioner number 1 pursuant to the death of the petitioner number 1, this court condones the delay. Now, this court substitutes the applicants applicants in IAC number 1381/2023 against the petitioner number 1. Further to that, taking into account that this is a proceedings under Article 226 of the Constitution, and the reasons so assigned in the application under being registered as IA Civil number 1380/2023, it is the opinion of this court that there has been no delay or laches. Accordingly, this court therefore substitutes the applicants in IA 1381/2023 as petitioner number 11, petitioner number 12, and petitioner number 13 to the accompanying writ petition. The petitioner is directed to file an fresh amended memo of parties before the amended memo of parties before a memo of fresh memo of parties before the registry of this court tomorrow. But tomorrow, you just file it. Only that, only name of the parties. What else is required?
The problem is that earlier there was another state of complaint. This repetition Lordship subcode is not available in my. So Lordship,
You have to put these names only. Who has filed this application? 11381. From 1 to 3 is already there. Number 2 you put, and the remaining 1 to 3 is here. Then by tomorrow. And on the basis of the said memo of parties and the order so passed hearing, the registry shall correct the cause title in the accompanying writ petition and further upload the same in the CIS. With the above, the instant writ petition in both the applications stands clear disposed. What is this?
Please, Your Lordship. Lordship, I have it filed by us. And which Lordship has said earlier this morning that it's a different case, Lordship. This is regarding Lower Kopili hydroelectric project.
Yes. No, there is some orders passed by this court.
That was a different.
Okay. So this order needs to be passed because that will be necessary.
Yes, sir.
The instant application has been filed by the respondent numbers by the applicant, who is the Joint Secretary, Department of Revenue, Karbi Anglong Autonomous Council, Dipu, seeking for a direction from this court that
That's one number 7.
to carry out joint verification of the total land required for the Lower Kapili hydroelectric project, redemarcation of the land if necessary, and to identify the project affected families due to construction of the Lower Kapili hydroelectric project. This application, however, have not been objected to either of the parties by the petitioners, who are the opposite parties in the instant proceeding, as well as the other state respondents. So taking into account, this court, in the interest of justice, permits the respondent, the Karbi Anglong Autonomous Council, to carry out the joint verification of the total land required for the Lower Kapili hydroelectric project, to carry out the redemarcation of the land, if so necessary, and also to identify the project affected families due to construction of the Lower Kapili hydroelectric project. With the above, the instant application stands disposed.
45.
And main requisitioner pass an order. List the matter after 3 months.
In the I appear for 80 and 81.
Give your name.
Yeah.
This repetition list the matter after 3 months. Madam, 3 months, I think you can do it.
Yes, in the other case, Dr. has directed them to give report on 29th or 29th of
January.
29th of January. The other report.
Will you be able to do this?
Oh, yeah.
So we'll have it in the list the matter on 4th of March. I think by then, I think the weather is dry. You'll also have your Karbi festival over by 12.
12, yes. 12 it will start, Lordship.
Huh?
It will get over by 19, Lordship.
Okay, then you can be, further the hangover would be there for another 10-15 days. Then by February, you would be able to.
Obliged.
But in item 45, but
45.
I prefer some accommodation here. But some vital, but some after going to the record, some vital facts are that we have seen that needs to be filed in the form of an affidavit.
Huh?
After going to the record of this case, we have seen that some facts are necessary to be brought to the attention by filing up an affidavit. But I think sometimes I'll file an additional.
What is this contempt for? What you call this review for?
Review.
Why?
Well, this is a review petition for review of an order passed by your lordship on 17th of February 2020.
Oh, so what is the error apparent?
Well, here we have filed the review for the subsequent.
So if it is a subsequent, where is the question of review?
Well, the para 93 of the Basic it says para 93 of the Basic it says that the review is. But we'll refer
Para 93
of the BCCI was the that
G cinema.
Yes.
G. Yes. What does it say?
But it said that on subsequent, because on the subsequent development also, the review can be filed for us when the question of miscarriage of justice is.
Where's the miscarriage of justice?
I'll take your lordship.
I'll dismiss it now.
No,
No, Mr. First of all, there was a direction of this court to comply with this within forthwith. We have not complied with it.
No, my lord.
Then if you have not complied with it, when was this order passed?
On 17th of February.
So,
My lord, the
you,
the
this
development-
court have, yes, you had some other action. You could have very well removed the suspension and then reinstate, then you take up whatever action you have. That's a different aspect of the matter. But is it this amount to a clear violation of this court's order?
Lordship may kindly allow us to file the additional affidavit or in the record.
Tomorrow.
There are some, look, yes, on third.
No, tomorrow.
On the real.
First of all, this is not a case for review. You go, I'll dismiss it, you go before the division bench. One thing good about it is that you can very well get a limitation. You file the review has been dismissed.
Look,
I'm not going to touch it unless the order of Justice Zamir is not set aside. Has that order been set aside? Tell me, if it has been set aside, that will be the only subsequent cause of action.
look, that judgment has been taken to appeal, although not by the government, by the private respondent of that case. That appeal was dismissed on 1/6/2023. Well, against that order, we have preferred a review. That against that.
Has that order Justice Jamir's, because this court had passed this order on the basis of Justice Jamir's order, not on the basis of any other order. So under such circumstances, the subsequent event, if we go into that BCCI judgment, is only to the extent that whatever was the basis have been eroded. That's the only subsequent. Now, if you get any further information that you have any problem with this officer, have it, no problem. But you can very well start a departmental proceedings. Have you started that? Have you started the departmental proceedings? Then under what provision you can keep him under suspension for such a long time, even as per the Judge Chaudhary's judgment? Under what provision can you suspend a person? No, whatever may be. What is the provision of law under which you can keep a person in suspension if you have not initiated any departmental proceeding?
Well, the file is moving a lot. Many actions have been taken.
But
Well,
why?
That is. But
Why does
I
it
just-
take 10 months for you to comply? There's a direction for forthwith.
Well, that development, I would like to bring it on record by filing. I think if
File it tomorrow.
Can it be
No.
third?
This court is not going because this is a clear violation of this court's order, and I'm very serious about my court's order. I'm very particular on my court's order. If you don't do whatever may be, let us see what was held by the division bench. Let us see.
Well, it has been upheld.
No, let me see what has been held by the division bench.
It has been
Categorically
upheld. Yes, it has been upheld, and the
No, not only that. Does the record the learned government advocate was directed to procure the service record of so and so, which was presented for perusal of the Iman and so and so. A perusal of this indicates that the cost of Timothy is recorded as OBC food. In the background, the learned government was directed to bring the facts on record by way of an affidavit. An additional affidavit on behalf of the state was accordingly filed on tender, bringing on record the relevant documents, including the service book of Sri Purnima Dutta. A perusal of the service book would reveal that the date of birth of Srimati so-and-so is so-and-so, and she was inducted in the service as a master roll worker in the irrigation department in so-and-so. As per the detailed information performer so-and-so, the caste of Purnima Dutta is recorded as so-and-so as good. In that background, the aspersion asked that the mother of the respondent procured caste certificate as OBC for the first time in a year is of no consequence. Comprehensive procedure for the issuance of social status certificate and the procedure for scrutinizing the genuineness or falsity of such social has been laid before the Supreme Court in so-and-so. As per the observations made in so-and-so, the inquiry into the complaint regarding genuineness of the social status certificate, the Director of Vigilance has to call for a report from the vigilance officer, which would be the inspector in the case, and if the director on receipt of so-and-so. Now we proceed to consider the judgment of so-and-so.
There are 15.
There are
51.
testing the report of the vigilance officer, that is the inspector CID, on the touchstone of the principal's Lieutenant Kumare Patel, we find that the inquiry reports submitted by the inspector does not indicate even in the slightest that the particulars given by the candidate were false or that the social status certificate has been fraudulently obtained. Thus, in terms with the first part of paragraph 20 of remand, which provides that in case the report is in favor of the candidate and found to be genuine and true, no further action needs to be taken. No further action was called for in the present case after the detailed and reasoned inquiry report had been submitted by the inquiry officer. However, the SLC got so and so of Durate, who apparently had no jurisdiction to carry out such inquiry as indicated above. Another significant fact which needs to be noticed is that as the report of the inspector which was submitted after conducting the inquiry did not give any indication that the social status certificate was obtained by respondent so and so by providing any false demand, rather concluded that the social status was validly and lawfully obtained. The authorities had no option but to accept the report and affirm the social status certificate of the respondent as per the guidelines in Kumaripari. Hence, the contrary conclusions drawn by the so-and-so is absolutely illegal and unworthy. As a consequence of the above conduct, we have the firm opinion it was justified in accepting the petition filed by respondent number 1 herein and quashing the speaking order dated so. Thus, the impugned order does not suffer from any infirmity. I'm dismissing your contempt.
Kindly see. The para 15 is the in fact the learned single judge judgment as well as the division bench judgment is based on the report of the vigilance audit. But kindly see now, I'm just taking your to page 55 of this review petition. Of this review petition, page 55. But in fact, it starts at page 54. The government under particular circumstances has examined how that report of the vigilance officer was it has submitted the report. Government has reviewed the situation and as per the direction of the highest authority, they have examined under what circumstances how the report of the vigilance officer was submitted. Kindly see page. I'm reading the relevant paragraph, page 55. The Digonto Purva village headman, it starts from page 54. This Digonto Purva village headman of Sekonidhora Gao, Jorhat East Revenue Circle, under whose jurisdiction Srimati Montun Prakapati currently resided, had provided a copy of the letter he received from Surendranath Pora, the then village headman of Doyingia Goalgao, informing that late Shiva Prasad Porkotoki, father of Pankonu Porkotoki, along with his family, was residing at Doyingia Goalgao, Moza, Misamara district, Golaghat before 1950, and they belong to Coast community. Sri Surendranath Pora, the then village headman of Doyingia Goalgao, denied issuing any such letter confirming that they belong to Coast community, thereby contradicting the statement of Digonto Purva, village headman of Sekonidhora Gao, Jorhat East Revenue Circle. So this certificate of Surendranath Pora, the then village headman, was relied by the inquiry officer while giving the report. And
Mr.
Unrebutted report, my lord. You're yet to rebut.
Mr.
Sorry,
Patwari, have we issued notice to you?
No.
That? What is this anxious?
I apologize.
Take your seat.
I apologize.
Well, these things have come up subsequently, and the next para also. So this is a report of 31/7/2023 when the highest authority, he have seen that the CID report is otherwise which has been considered by the honorable court, and the state level committee's report is different. Then the authority has decided or they directed to see re-examine the thing. Then this was
Mr. Nath, you have to reinstate him, and thereupon you draw out further disciplinary proceedings and suspend him. You do that. But what you have done out here as of now, I don't understand what type of legal recourse legal advice you have taken out here. Yes, let us assume that everything is wrong. He has done all these things very well. But till the order of the division bench as of now is not set aside, you don't have a basis to suspend. Your only basis to suspend will be drawing up disciplinary proceedings against him and suspend him fresh, not on the basis of that. Because your suspension, which was done at that point of time, was on the basis of the order being passed by that authority, which was set aside by Justice Zamir. So under such circumstances, unless and until you don't set aside that, you can very well now, yes, that those facts were not available then. I really appreciate it. Those facts were not available then. Now on inquiry, you have come to learn, for which it will be a separate cause of action for the purpose of initiating a departmental proceeding. And to suspend him, you can do that. That's a different thing, which will be a separate cause of action. But I am not understanding why you are bent upon not seeking a review of this. As of now, you cannot.
But we have.
You don't have the basis.
But we have
I'm telling you, Mr. Nath, kindly appreciate. If we go by the BCCI judgment, the BCCI judgment says of subsequent events. Yes, tomorrow Justice Zamir's order is set aside, or the division bench reviews his order. It would be a subsequent cause of action for the purpose of seeking a review. But as of now, it has not been done.
We have filed
It is your review petition is premature.
we have filed a review petition before the division bench for review of the division bench. That in that not notice the division, the matter has been, that order we have.
I am dismissing it on the ground that it is premature. You will be at liberty if there is a change of circumstances in the division. As of now, you don't. I'm telling you.
The circumstances kindly allow me to bring it on record.
Tomorrow. Tomorrow.
Tomorrow.
Then I'm dismissing it. Go to the appeal against this. The division bench may help you out. I am not. No, Mr. Nath. Mr. Nath, what you have done is this. I don't understand. When the matter was taken, in fact, I was, with due respect to the courtlet bench out there, I was not satisfied with Justice Zamir's order. The more particularly, the entire conclusions comes in one paragraph in the last paragraph. I was not. When the matter was taken up out here, I asked the authority, have you not filed an appeal? The state said, no, we have nothing to file. It is these people who have filed. That was the specific thing. That is why I still remember when I was dictating, I dictated the judgment in open court. It was 42, isn't it? Huh?
Mr.
You have all along agreed to this. You have a change in opinion, change of heart with that officer, very well, have it. I'm not on that. But the fact is, for subsequent events would be, as per G Cinema, would be on G Telefilms, would be if that order, on the basis of which this court passed that order, is no longer there. Then obviously, I give you I'm holding it, it's premature, I'm dismissing, rejecting it. However, I'll give you the liberty if anything change in circumstances happen. As of now, you don't have. That subsequent, because what actually you should have done, which I should not be telling you, is you should have very well, okay, whatever may be, you initiate departmental proceedings. Go ahead. Do the departmental, and you, on the basis thereof, you can exercise 6 ones. And again, suspend him. You can very well do so, because now you have got these materials which were not there at that point of time. But what are you doing out here? You are fighting out there. these particular material, I don't understand. These particular, you are again seeking review. If I was a lawyer, I wouldn't have. Now, kindly appreciate. The order which has been passed by the division bench was on the facts of that case, when these materials were not available. Now, these materials being available, you can very well seek a review of that order. Best, if you want. But by doing that, you are again putting your foot out there in muddy water. But here, the question of review does not arise unless that order is not there.
What is in our mind? If a person is not, it is still for us the note prosecutor possibility, the note of the notes the what is in our mind that the status is under very the authenticity of the OBC status of so is in serious doubt. That is the view of this is
let it be.
Well, there is no
but let it be. I am not on that. You have serious doubt. No, Mr. Nath, kindly appreciate one thing. You have a serious doubt. You have got new information for which he is. Suspend him. But freshly, not on the basis of that continue. Because that would be in violation of this court's order.
That is the,
think about it tomorrow.
That is now my
Tomorrow at 10:30. I'm picking it. Think about it. And take an action, which I am telling you. This would solve your entire problems from filing review, this review, that review, or whatever may be. Because now you are in possession of new information. As of now, the question of me reviewing this order does not arise because as of now, the basis is not there. The basis of subsequent will be if that order is set aside. Forget about that order. Till Justice Zamir's order is not set aside.
That order has been marked in the retapel order. Again,
Understood.
the retapel order
Understood. Therefore, that order has to be set aside.
It is
not only set aside, it has to be set aside. No, kindly see. How is the review done? First, you review. The moment you review is, once your review application is allowed, what happens? The appeal is reopened. So first, not only the review, the moment the review order is allowed, it will happen that the appeal will come. But then also Justice Jabi's order still remains. It is only when an appeal, with the writ appeal, when it is again heard, then only you can. But as of now, not one, two, three obstacles you have. Then only the subsequent event will come here. Think about it. I'll take it up there tomorrow at 10:30.
Can I read it?
2 o'clock? 2 o'clock? 2 o'clock.
Alleging non-compliance, you find the contempt, personal appearance was given.
Yes,
that
yes,
is
I have anything.
No, I am not on. No, Mr. Patwari, first and foremost, you know, even in a motion matter, till I don't issue notice to the other side, I don't entertain whatever they have to say. I am not going to entertain anything, and more particularly a review. See, the review jurisdiction is a very different jurisdiction. First, this court has to be satisfied that some prima facie case is made out. Then only this court will issue notice. Then when notice, you file your objection. Once you file your objection, then only the question comes as to whether to review or not. Once you review it, then the appeal or the petition will come up for hearing. Yes. This is how the manner is. This is the matter tomorrow.
It is in the mind of the authority that if the person is not deserving, he should not.
Absolutely. I am no Mr.
He should not for a minute
Mr. Nath, I am in full agreement with you. But you have also think about the rule of law. What is being happening out here? If this thing is being condoned out here, that will be then what is the point of passing orders? There's no point. You may one day, I'm not saying, yes, this may be a very deserving case where you need to intervene. In all cases, your authorities will say, why should I? Appreciate that. This is a very serious thing because as of now, that order passed by Justice Jamir is still intact. Not only that, it is further being cemented and layered with the order of the division bench. So As of now, for that subsequent cause of action, event is not here. Yes, for that you may very well say before the division bench as regards the subsequent cause there, but not here. Take it up tomorrow.